Welcome to the 32nd meeting of the Committee for Justice. The meeting is now open to the public. Members, just a reminder that the committee meeting will be recorded and broadcast throughout Parliament buildings and online. It's proposed that the oral evidence session with the Minister of Justice and the oral evidence session with Forensic Science Northern Ireland on the Justice Bill be recorded by Hansard. Are members agreed?
Agreed.
Thank you. Also, members, just a reminder that we're obliged to declare any financial or other relevant interests that might reasonably be thought by others to influence our approach to matters under consideration. Anybody who's got any interest to declare in relation to today's business should do so now or when the particular matter arises in the course of the meeting. Does anybody have any interest they wish to declare at this stage?
Oh, an immediate family member who works in the court service.
Thank you.
I'm the same, immediate family. And the probation board, sorry.
And I have an immediate family member who works in the legal profession. We also should note that
members of the all-party group.
yes, a number of us are members of the all-party group. Apologies. I'm going to work on the basis that I've got an apology from Morris, who was unwell, and we wish him a speedy recovery. And as you can see, members, we've got Doug Beattie and Justin McNulty with us virtually. Agenda item 2 is the draft minutes. That's at pages 5 to 14 of your pack. Are members content that those are a true and accurate reflection of the proceedings of the meeting?
Agreed.
There's just one thing on page 12. Actually, there are two things. I'm just going to flag up. No, sorry, one thing. Just with regard to Justin's query around the billboards, just so for accuracy of what we've got here, it says Justin McNulty raised an issue about political parties illegally posting information on DFI billboards. The issue is not the DFI billboards. The issue is it's illegally erecting billboards on DFI land. Are members content that we make that change?
Yeah, agreed.
Thank you. So whenever that's done, then I'll sign the minutes. Matters arising. Can I ask you to turn to pages 3 and 4 of your table pack? At last week's meeting, the committee considered a response from the taxing master to its invitation to provide oral evidence on clause 28, and that's the restriction on ordering taxation of legal aid costs of the Justice Bill. And in that response, the taxing master advised that the judiciary don't comment on policy matters. So members agreed that the committee team would draft a letter collating a list of issues that have been raised in evidence received to date for the committee's consideration in advance of issuing to the Lady Chief Justice. That letter to the Lady Chief Justice is pages 3 and 4 of your table pack. If members would just take a look at that, are you content with that draft, or is there anything else you want to add in? The only thing that occurred to me was, do you remember the bar raised the issue about the potential for a two-tier system, about if costs are awarded against you?
Yep.
And the impact that that might have, because the taxing master will be doing his work in the private aspects of legal aid, but the department would be dealing with it, or sorry, let's move legal aid of legal fees. But the department would be dealing with legal aid. So they were flagging up there was potential for a bit of a two-tier thing there, particularly where costs were concerned and the awarding of costs. Would members be content if we were to add that in and see if the taxing master has any comment to make on that?
Yeah, sound.
Great, thank you. Does anybody, oh, Morris, you're welcome. Does anybody have anything else?
Sure. Apologies, I'll have to leave early because I'm meeting in Korea.
It's all right, Morris, we're glad to see you. I had put your apologies in, thought you were unwell. Well, it's good to have you with us. Morris, we've taken kind of a list of the areas that people want to come in on questions. If there's anything, would you fire through to me, please, and then we can add your name to the list. That'd be great. So with that addition, are members content that that letter is issued, or is there anything else you wish to add?
No, content.
Right, thank you. Agenda item 4 then is the ministerial briefing from the Minister of Justice. So I would ask members to turn to page 16 to 127 of the meeting pack and 6 to 135 of the table pack. Members, I just want to say apologies for the very significant table pack that there was. You appreciate that that's not something that we normally do, but given that the Ombudsman's report was going to form part of our questions to the Minister today, we figured it was important that members would have a chance to get a look at that report. Minister, welcome. Hugh, welcome. Deborah, it's nice to have you with us. Welcome.
Thank you.
So, members, you'll see we've got the Minister for Justice with us, Naomi Long. We've got Hugh Wittes, the Permanent Secretary, and Deborah Brown, who's the Director of the Justice Delivery Directorate. Minister, you and your officials are very welcome to the meeting. We look forward to hearing what you have to say, and then afterwards we've got some questions. I'll give you some idea of the subject areas just so that you can know where we're coming from. Obviously, we had 5 areas in which we had highlighted our interest to you in advance, and that would be the criminal bars strike, the Cresswell case, where's my list? The Policing Board review, the Civil Service Handbook, the Police Ombudsman's Office, and then around some other issues that are going to be raised are going to be the minimum age of criminal responsibility, reasonable chastisement, transformation bids, violence against women and girls, the prison service, remand and sentencing, and some issues around domestic abuse and the PFG. So nothing there that's going to cause you any difficulties, I wouldn't have thought.
Well, we'll see. Depends on the question.
No, I'm sure it's fine. I mean, the issue here is, you'll know, our aim in all of these things is to be as constructive as we can, and where we may disagree, that's fine, but we'll disagree constructively and respectfully. So thank you very much. Also, the domestic abuse waiver may also feature in there somewhere too. So we're going to hand over to you for opening remarks, and then we'll turn to questions. Thank you.
Perfect. Well, first of all, thank you, Chair, for the welcome, and thank you to members of the committee. Very much appreciate the opportunity to meet with you today. I'm going to be keeping my opening remarks quite brief because I realise there are quite a few things that you want to go through at this stage in the mandate when we've had a year in. It's very different than the people, I suppose, have more issues that they've got their teeth into and have particular interest in. I know that officials have been attending the committee regularly, and I trust that has been helpful. We obviously value your input into the work of the department as we seek to try to advance our priorities, and so hopefully that engagement with officials is helpful. Obviously you've discussed the issues that you want to raise, so I'm going to keep these brief so we can spend as much time as possible on those. I do just want to touch on a few current issues, but of course we'll be open for questions afterwards. Firstly, just to note the publication of the Programme for Government last week. Publication, I think, is an important milestone for the Executive, and it shouldn't be underestimated. The role of government is to protect its citizens, keep communities safe, and help them to feel safe and secure, as well as having the confidence they need to live productively and engage fully in society. I'm really pleased, therefore, that the Programme for Government includes the Safer Communities priority. And while the work of the department largely supports that priority, it won't be something that is solely for the Department of Justice, and I think we explored that earlier this week, even when we were talking about things like drug misuse and substance abuse. So it is important that we do work in partnership with other departments, which is why I think having it in the Programme for Government as opposed to simply as a departmental priority is so important. We also will be collaborating and continuing to work closely with other statutory agencies and voluntary and community organisations. I think that's critical if we're going to achieve our shared objectives, such as reducing offending and reoffending. I'm also very much aware of the narrative around police numbers, and I concur with the Chief Constable's ambition to stabilise and recover police officer numbers back to a more sustainable position. Members will, of course, realise that the 2 periods where police officer numbers fell most dramatically were when we didn't have the oversight either of a Justice Minister or of a committee here at the Assembly, and when the Assembly wasn't sitting. That was true when I came into office in 2020. There had been a drop-off in police numbers to around 7,000. And during that period of 2 years when we had an Assembly and Executive established, we managed to raise that to 2,100 through some budgetary allocations that were made during that time. However, then with the suspension in 2022, those numbers dropped again to, I think, a considerably lower level of 6,300. I can explain further, obviously, members want to explore it about how that came about. But I think what's really important now is, first of all, that we have recognised collectively as an Assembly and as an Executive that we need to look at the increase in police numbers, and that needs to be done with a degree of pace. It also needs to be affordable, and so I've repeatedly raised with the Secretary of State the need for better financial settlement for the Department of Justice, as well as with the Finance Minister and other executive colleagues, and I think that message is more clearly understood perhaps than it was in the past. I'm also pleased that a business case now has been submitted to the Department of Finance in the last month to move to workforce levels up to 7,000 officers again and 2,572 staff over the next 3 years. So that's been working in collaboration between the department, the Policing Board and the Chief Constable and PSNI. It is incredibly difficult. You'll be aware of the figures that we've talked about for that. So it works out at about £40 million per year for 5 years to do the recovery piece of work that we want to do. That's obviously not guaranteed. It will have to go through the normal budget processes. But I would be reasonably optimistic. I mean, it's a lot of money. I certainly don't make out anything other than it is a lot of money. But when you compare it to the potential harm that could be caused by not actually taking action at this time, I think it will be good value for money, which is really important in terms of where we want to go. It is increasingly difficult, I think, though, to see how we can continue the current trajectory in terms of the justice system unless we get that injection of funding and without significant deterioration in public services and lasting damage to our citizens. Of course, that's not unique to DOJ, and many of you will sit in other committees or will talk to your colleagues who do. But the severity of the financial position for the justice system is exacerbated by the combined effect of historic underfunding compared to need, the demand-led nature of the majority of services delivered by justice organisations, and I would also argue the fact that on so many occasions justice is the service of last resort. So when other services are creaking under the weight and the pressure that's being applied, it ends up coming to justice to pick up the pieces, and that has led to an increase in both the complexity and the amount of pressure on the department. I know that colleagues have updated you already on the budget for 2025-26, and you'll be aware that we are facing significant challenges across the justice system. It's also important to bear in mind that reductions in spend in one area actually really just create pressures in another business area and will cause further damage to the system as a whole, and that will cost more to rectify in the future. I think to say that there are some departments that I think were you to throw the entire budget at them right now, you still would not get the outcomes that you would desire because there are dysfunctions that need to be addressed. I don't believe justice is in that space. I actually believe that with measured investment in the justice system at this time, we can prevent us reaching a point where the system is so broken that it's almost beyond repair. I also believe that where that money is invested, it will be spent wisely, and I think the transformation bids that were announced by the Department of Finance last week are indicative of the fact that DOJ has made very strong bids in terms of the transformation, and some of those bids which were not successful, we are proceeding with as business as usual because we believe that it needs to be done anyway. I think it's also important in terms of the committee to be assured that I will continue to advocate strongly for those additional resources for the department and trust that I have the committee's full support in that. I do want to pay tribute, I have to say, to the Department of Finance and to the successive Ministers of Finance in this regard, in that our settlement this year, had it followed the trajectory of previous years, would have placed us in a completely impossible position. I think they've recognised that, and so whilst our settlement now is still very challenging, I think we are in a better place than we may have been when we returned to the executive 12 months ago, and certainly a better place than I anticipated we might be if the trajectory continued unabated in the direction it was going. I think the appetite for reform and transformation within the department is not diminished, and I think, as I've referenced already, 2 of our projects that are being funded through the Executive's Transformation Fund were successful, and I think that shows our commitment to transformation, but also our ability to produce a strong case and show how that transformation will actually lead potentially down the line to increased efficiencies and also better delivery of service. I also just want to finish by saying a few words about the withdrawal of services by the Criminal Bar Association. You will be aware we had a considerable discussion about this earlier in the week, and since those services were withdrawn, I have been deeply concerned about the impact on victims and witnesses. Jerry Hanna, the Victims of Crime Commissioner Designate, has echoed those concerns even this week. I want to reassure members that notwithstanding the challenges that we face in the department, I have consistently and will continue consistently to reach out to representatives of the Criminal Bar and to the Bar Council because whilst as I explained, I feel that the list of concerns have been shifting. I do feel that they have also been diminishing in terms of those which we're able to address effectively as a department, and therefore it's important that we keep those lines of communication open, because I think what all sides would like to see is a return to full service as quickly as possible, and that's what I would like to happen. I was able to update members, obviously, with the Enabling Access to Justice programme on Tuesday, and I want to make reasonable, proportionate and timely remuneration for the work undertaken, but we do need to have that evidence base, and never has that been more important in a context where I am essentially competing with education, health and all of the other departments for the resources to be able to implement change. So that has to be robust, and if the case is robust, I mean, they will not find anybody who will argue harder for their case than I will, because I'm absolutely committed to ensure that those people who have invested in their career in terms of their skills and their professional development and who are providing a high quality service are remunerated in a way that will continue to allow them to do that for the benefit of citizens, which is ultimately who legal aid is for and is awarded to. It's not to individual professionals, it's to ordinary citizens. And I've said many times, as members will recall, that I see this as part of our wider welfare safety net within society. I do think we have an opportunity to reset the framework for justice delivery, and what we want now is for those services to return to normal so we can focus on that work and don't end up having to expend resource on recovery of the justice system from the strike. Finally, I know that you've been receiving regular briefings on the Justice Bill, and I do hope that those are helpful in your consideration for the bill. Obviously, there are other, legislative reforms that I would like to have been able to bring forward. Initially, the legislative programme for this mandate was 5 bills, and that has had to be reduced. So I've had to prioritise, as you're aware, because of the lack of an Assembly and Executive for those 2 years. However, by prioritising, we have looked at those who are most vulnerable and what we can do to actually ensure that the changes we make in this mandate are able to support them most. And so there will be things come the end of this mandate that we will have done preparatory work for, that will be able to be taken forward by whoever is Justice Minister in the next mandate. And there will also be work, obviously, that we will want to do at pace. But it's to say that I think there are real opportunities if we can have a sustained period of functioning Assembly and Executive for us actually to not just catch up on those things which needed to be done because of the various suspensions, but also get ahead of the curve, because I think that there's some really good practice that's happening in Northern Ireland which others are interested in adopting elsewhere, and I think we should be very proud of that and not hide our light under a bushel in that regard. And so I've been engaging both with my counterparts in London, in Scotland, and in Wales, and also in Ireland, just to ensure that where we can learn from best practice elsewhere, we can do that, but also where they can learn from our practice, where that is best practice, we're able to share that experience and knowledge and hopefully get good resolution for the citizens right across these islands. Thank you.
Thank you, Minister. Other members? We'll just work through as we agreed then. Minister, we're going to work through the topics in order and then we'll come to various other subjects at the end. So with regard to the Criminal Bar Association, I've got 3 questioners. I've got Justin, Deirdre and Stephen. So Justin, kick off there for us, please.
Thanks, Chair. Thanks, Minister, for your presentation thus far. Minister, I welcome the news this week of the pay uplift for the bar. Going forward, given the tone of your statement earlier this week, I have concerns about the relationship between the department and the criminal bar and that it remains strained. Looking to the future, is there a risk that further deterioration in this relationship could lead to more strike action? And what assurances can you give to victims and witnesses who are often the most vulnerable in our society that they will not become collateral damage again? And have you considered mediation as a means to close the gaps on the issues outstanding between the department and the Criminal Bar Association to ensure that this does not happen again?
Well, first of all, to say that yes, the relationships, it would be fair to say, are strained at the moment. That's certainly the view of the Criminal Bar. It's not something that necessarily I would lay at the feet of my officials who have gone out of their way and above and beyond in terms of the level of engagement that they have had with the Criminal Bar in terms, and with the Bar Council, I have to say more widely, because of course whilst the Criminal Bar are currently on strike, the rest of the bar are also benefiting from the changes that we're bringing forward through the Enabling Access to Justice strategy. I think in terms of that strain, I have met with the bar, I have discussed directly with the Criminal Bar my concerns. And look, at the end of the day, relationships are a two-way street in all regards. So I am willing to do what I can in terms of trying to reach a settlement with them that they are content and satisfied with. but it has to be one that is based on evidence. And so partly what we did in terms of trying to resolve the outstanding dispute with the criminal bar was to engage Judge Burgess to undertake the work that he did. He came back with very strong recommendations, which we have accepted and that we are implementing as part of our overall Enabling Access to Justice programme. So from my perspective, I think we have gone a long way to try to meet those concerns. Now, if there are additional concerns, and I would argue that perhaps the biggest concern at the moment, and certainly when I met with the bar before, was first of all that they believed I would not act at pace. I think I've put that to bed in terms of how quickly we have instigated those initial actions which are most impactful for the bar. And the second was, I think, a lack of trust. And I will say to the committee what I said to the bar. The only way we're going to rebuild trust is if they walk with me on this journey. We can't rebuild trust by simply sitting on opposite sides of a table and engaging in a negotiation. I have shown my willingness to do this work at pace. I've shown my willingness to accept the recommendations that Judge Burgess implemented. I have shown willingness to take cognizance of their concerns, even with some of the other parts of the programme, in terms of the order in which we're implementing it and considering it. We've looked at things like, for example, how quickly the bar would feel the benefit, because you will be appreciative of the fact that solicitors would feel a more immediate benefit from an uplift in fees than barristers, who often have to wait a longer time to be paid. And so we've looked at the issue of interim payments, and that would be an administrative issue. It wouldn't require them to submit further bills and do further work. It would actually just be an administrative process that would allow them to receive, for example, at 50% of case complete, that they would be able to receive 50% of their payments as opposed to wait to the end of the case. We've looked at all of those things, and we've set up the working group that Tom Burgess asked us to set up, which was to bottom out the remaining evidence base. And I think, look, if you want to judge me on what I have done. When I was asked to do the 16% uplift, and when the department initially received the 16% uplift as a recommendation, you can imagine that eyebrows were raised because it is a significant uplift. But I've actually agreed that it is necessary, given that it is the first uplift in 10 years. So 16% sounds like a lot in one go. But what we've also tried to do through the working group and through the work we're doing now is ensure that we don't have another 10-year hiatus before we next look at fees, because that's been part of the problem. And there are a lot of factors that have contributed to that delay. I think what we need to do, though, if we're going to rebuild trust, it is a two-way street, and it is about saying, now that those main issues that were raised with me have been addressed, it is time to go back to full service. I will work through the remaining issues in terms of, for example, concerns about complex cases. I know a number of members raised that with me on Tuesday. I will work through that, and we will get the evidence that we require to substantiate any further uplift. So this is not about placing hurdles in the way of resolving the problem, but it is about being honest, because, of course, Justin, you're absolutely right. It is the most vulnerable. It is victims, witnesses, and I have to say defendants also, who suffer. Many of those defendants, we know we're going to be talking later about remand, are currently in custody and yet have not been proven guilty of any offence. That is not a situation that we should be countenancing, and it has attached to it costs that actually are to the detriment of the wider justice system. I want to see it resolved. If the CBA want to see it resolved, then we're able to do it. The final part is the issue of mediation, and the reason mediation I don't believe is appropriate is I am not an employer in this situation, and I think that there is a danger of entering into mediation as though this is a two-way conversation between myself and the criminal bar. First of all, I have to respect all parts of the bar. Not just the bar. I have to look at the immigration solicitors issues. I have to look at immigration payments more generally. I have to look at the family bar. I have to look at civil bar. So all of those are part of the consideration that I have to take into account. But I don't ultimately employ barristers. That's not my role. This remuneration and their remuneration is a matter of them being employed by members of the public. So what I am trying to do is ensure that those members of the public are able, through the legal aid system, to be able to get a barrister to take their case. That's ultimately the role of the legal aid system. But there is no mediation, if you like. There is no halfway point that we can meet at, because I am not the employer in this situation. So it isn't like another remuneration dispute where I can simply enter into negotiation and reach a figure. And further to that, this is also not about saying, well, you know, how do we how do we reach a conclusion where everybody's satisfied? This is about saying, what is the evidence base? Because legal aid is there to pay for work done. So we have to understand the complexity of that work, the cost of that work, the time taken to complete that work. And we have to ensure that that is open and transparent. So simply entering into a situation where we barter over the figure doesn't actually tie it back to the key thing which comes through in PAC inquiries and so on into this area, which is that it needs to be evidence-based. But I've already said to the criminal bar and to other parts of the bar, where they have evidence that their work has become more onerous, more complex, where it is actually taken up more time than it previously did, and where that link between remuneration and effort has to their view been broken. If they can present the evidence of that, we will take that on board as a department and look to address it in the same way we have with the 16% that was evidenced. So, I mean, I'm confident that if the bar, to put it bluntly, being not providing full service is not going to change the varies of what I can do in the Department of Justice. So there is no leverage to be achieved here by remaining in the withdrawal of services. It is simply forcing us to look at other alternative methods of provision. And that's not a route that we want to go down. It's a distraction to the department's business, and B, I fear that any change to how we do this, any change to people being free to choose their own barrister and all of those other things in an open market, I think would be deleterious to the objectives we have, is that everybody has equal access to justice. So I don't want to go down that route. I want to focus very much on resolving this dispute, but it has to be on the basis of hard evidence.
Thank you.
Minister,
Justin?
thank you for your long answer. And mediation is not just for employees in situations, it's for two sides cannot meet at the middle, and that's why you may consider that. Given the strained relationship, can you reassure the committee that submissions from the barrister profession on legal aid remuneration, the enabling access to justice delivery plan, and through the independent working group will be assessed objectively?
I can give that, absolutely. Of course we will do that. We have, in terms of the work that's already been done, because remember, the working group isn't something that's happening in the future, it's actually working now, and thankfully the criminal bar are at the table along with everyone else. But that's already happening. So we have our departmental economists and our statisticians there actually providing input, scrutinising the figures and helping to assist to find the evidence base we need. I am not trying to deprive people of money that they have rightfully earned, and I want to see the profession flourish. It's important for the justice system that they do. I can't do that alone. It requires the Law Society and the Bar to be partners in that. And to be fair, the Solicitors Criminal Bar Association have been partners in that and are working very quickly with us at pace, for example, to look at issues around PACE interviews and the cost. I mean, there are few of us, to be candid, who would want to be called out of our bed at 3 a.m. to go to a police station to deal with a case in custody for, I think it's around £40 at the moment. There are few of us who'd want to be in that situation. And so we have to be realistic. If we want the profession to be sustainable, we have to pay people at a rate that is appropriate for the disruption to their life and takes account of unsociable hours and all of those things that we would expect. Those are all issues that we are dealing with at pace. And if, as I said, if we can get that closed down in time, we will include any additional uplifts to the 16% within the secondary legislation that we hope to bring forward in May. So it's not something that we're putting on the long finger at all. The sooner we can get it resolved, the sooner we can get the evidence bottomed out, the sooner we will be able to get a completion to this. And that's what I think everybody wants. I can't give guarantees in terms of whether or not the evidence brought to us will stand scrutiny, but I can give guarantees that it will be given a fair hearing.
Fair enough. Okay, Justin?
Thank you, Minister. Thank you, Chair.
Everybody, and Minister, I'm just conscious we've quite a list. So
hopefully the rest will be slightly less
I
contentious.
have everybody well warned about preambles. Right, Deirdre?
Yeah, no, just following up, and thanks for your update so far, and obviously the statement the other day. And I think it seems to be a negotiation that's nearly playing out in the public, and I think we all want to see an end, obviously, to the action that's ongoing at the moment. So it is just to say, I know that you'd met with the bar, I think it was on the 18th of February. So are you going to do a follow-up meeting to try and look at finding a resolution? I'm not saying it's a mediation process, but to try and bottom out whatever issues are there. And I know you touched on it again in terms of your statement the other day around alternative models. And I think everybody was concerned about that, the fact that it was in the statement. What alternative models, you know, obviously it's in the statement, so you have been looking at options. So can you give any kind of flavour as to what you are looking at?
I think there are two parts to that. I think first of all, it's important that now that Tom Burgess has agreed to take the working group forward, that I now put this in his hands. I think for me to go around that formal structure that we've put in place to deal with the issues around remuneration, for me then to engage in some kind of back channel would be inappropriate and undermining of the work that he's doing. I think the professions asked for somebody independent to chair it. Initially, I'd suggested that one of our departmental economists or statisticians could chair the working group, and for obvious reasons, because of lack of trust, that I referred to earlier, the profession were not particularly content with that. So I reviewed that position. I spoke to Tom Burgess. He was willing to take the work on, and so he is now chairing that working group independently. And that was one of the things that they'd wanted as part of this. So I now need to let him look at that evidence, because you're right, it isn't a negotiation. I will continue to engage with the bar on other issues, because there are many other issues than simply the dispute with the criminal bar, where we are on the same page and trying to achieve the same objectives, and I want to work with both the bar and the Law Society to deliver what they want, which is a stable and sustainable profession. Not all the levers are in my gift, but there are things that may be, and I'm happy to work with them. So we will continue to meet, but I do think on the issue of remuneration, we've now handed that over for an evidence-based process, and I need to let that run its course rather than engage in further negotiation. In terms of the issue about alternative mechanisms, I highlighted it simply, Deirdre, because I think it's important that members are aware that if this continues for a prolonged period, this started in December, we're now sitting in March, we don't know what will happen for the rest of the spring and summer. And if this continues for a sustained period, what that means for individuals and for the justice system is stark. So we do have to now look at scoping out alternative ways of providing for defence. In the same way that we have alternative ways that we have a public prosecution service. Now, I am not enamoured of the idea of a public defender's office. I've always been really clear that I think that one of the important things that we have is the freedom for an individual to choose their own defence and not to be limited in how they do that. But one of the conversations that we had most recently with the bar when we met with the criminal bar was that they said that in those category A and D cases and in retrials, that the remuneration simply did not make it sustainable for them to continue that work. Now, that goes beyond simply saying that we need the 16% uplift or the tweaks for more complex cases that we're currently talking about. If they are saying that it is just unsustainable for independent barristers to do that work, we will have to look at a different delivery model, and it would be reckless of me, frankly, as Justice Minister, not to be asking officials to start to scope that out. However, it's at very early stages, so we're not settled on models, we're not settled on what options might be available. There may be hybrid options that are available, where we look at particular retainers for people who work in, for example, the criminal system, and we look at that as a separate issue. There are also wider points. I mean, while some people within the criminal bar will be very highly remunerated, and that was drawn out during questions, there will be those within the criminal profession who struggle to get work. And it may be that some of those people would be willing to do the work were we to have a different structure in place that would allow them to gain a high court experience, would allow them to be able to get a foothold in the profession. And if there are mechanisms that we can do that, we need to explore all options, because what we can't have, frankly, is either through this dispute or through future disputes, because I think this is now the 5th dispute there has been with the criminal bar specifically. We can't allow the justice system to have all of the positives in terms of accelerating justice, and there have been positives. So we are seeing justice actually speeding up. But every time we are getting to the point where it's starting to speed up and we're turning a corner, there's a dispute and we end up going backwards and having to invest money in recovery. That's not a sustainable model. So if we can resolve this with the criminal bar, and we can resolve it for the longer term, including the more regular reviews, then I think that we can park any discussion around what else we might need to do. But in the interim, and until I have some sense that the bar are intent on coming back to full service, I will have to scope out what alternative provision might be necessary. That's not something, by the way, that could happen overnight. But it is something that we will have to look at in order to ensure the sustainability of the justice system as a whole.
Just for clarity, so I suppose at this point in time, there's no specifics or timeline to that in terms of what was in the statement. And just to go back on the first point, sorry, in terms of the engagement, because it probably is more than just about the remuneration. So I would be keen around what ongoing engagement the department is going to have. You know, the issue come up the other day around reasonable adjustment during this period, and you know, whatever time it's going to take, I would like to be sooner rather than later that a resolution is found. But if it's not, is there going to be a proactive engagement with the department and the bar looking at those issues beyond the remuneration issue to try and get a resolution as quickly as we can, you know, for everybody?
Well, at this stage, the dispute is solely around remuneration. So the issues that the criminal bar have raised with us is solely that they don't believe they're being fairly paid for the amount of work they do, that it isn't the model isn't sustainable in that regard. So that is solely what it's around. And I think that the work that Tom Burgess is doing may be able to deal with that more robustly. I mean, Tom Burgess looked at the criminal bar specifically and came up with 16% uplift. As a department, we accepted that if we were going to apply that to the criminal bar, it should apply across the entire bar, because whilst there are uniquenesses to the criminal bar, the same passage of time has affected other parts of the service. We also need to look at the age and gender profile, for example, of those who work in different parts of the bar. So to apply the uplift in only one part of the bar could be problematic unless there is a good and strong reason why we would do that. And that's where I think the evidence base that we're trying to seek with Tom is really important. If the criminal bar can show us that there is a strong reason why certain fees need to be changed, then we're open to that. I think in terms of wider engagement and the sustainability of the profession, look, there's a whole host of things that play into that. The fact that many young barristers find it very difficult to take cases and to be able to get cases. The fact that, there are many people who are called to the bar and end up not actually continuing with a career at the bar because they simply cannot access enough work to be sustainable. And we need to look at that. We need to look as well, for example, another problem that we unearthed but have not yet found a solution to, that we are engaging with the bar, is around the fact that, for example, women who go into the legal profession and are at the bar may find a case lasting across 2 years. They may do 18 months of work, find that they're pregnant, aren't able to actually represent their client in court. Somebody else will take that case over and they will be paid for that case, but the person who did the preparatory work for 1.5 years gets nothing. So that is something that we're looking at, and interim fees will help with that. It won't resolve it entirely, but interim fees will help with that, ensuring that if you do the work, whether or not you actually make it into the courtroom, you should still be paid for that work. So those are the sorts of issues that we are looking at, Deirdre, because it is important to me that the profession is sustainable. But it also is important that we have an evidence base on which to move forward, and that's why I've said we will continue to engage with the bar, with the criminal bar, and with the Law Society, and with others, remember, who also provide legal advice and guidance in this space, because there are other organisations, whether that be Housing Rights or whoever it might be, who are also providing advice and guidance to people through a different model and a different scheme. There are other immigration solicitors and so on who operate through a different model. So we need to look at how we ensure that ultimately we put the citizen at the heart of the system and focus on that and how we provide that service best. But I want to do that in a way that sustains, first of all, equality of access, so that those who are reliant on legal aid do not get a second-rate service. And that's one of the reasons why I would like not to have to explore any other kind of contracting arrangements, because I think there is a danger in that that's not the case. And the second thing is that I want to ensure that the profession is able to flourish, because they are part of the justice system, albeit that I am not directly responsible for them.
Okay, Deirdre, I'm really conscious of time at this stage because we've a lot to get through here, so we need to really, so everybody, apologies, Master, but you included, as succinct as we can, please.
I will do my
Doug.
best.
Thank you. Doug?
Thank you, Chair. Thank you, Minister, so far. Minister, I said to you in the chamber during the week that you're treading a difficult path. You really are. I'm really concerned about these derogations that you try to get in for the 17 most vulnerable cases that fell through. have you considered any legal recourse to take against the bar to try and help those 17 most vulnerable cases?
Ultimately, in those cases, the person who the defendant has a right to choose their own barrister. So the relationship, if you like, the contract, not that it is a contract, but that relationship is between the individual and the person who represents them in court. So there isn't really that opportunity. Nor do I want to be in that space. I actually don't think repeat litigation either by the bar against the department or vice versa is actually where we want to be if we're going to try and build relationships. There has been, I think, even since Tuesday, some further progress in terms of engagement, and there were 7 cases that had to be adjourned because of the withdrawal of services that have yet to be listed again. We don't have the reasons for that as yet, but those are cases which didn't go ahead because of the action and they don't have a new date. There are 3 that will commence next week. So 3 of those cases that were of concern are going to commence next week. So that's 3 of the 17. And about 10 of the 17 have now got a date scheduled between March and September. But you also need to bear in mind that depending on what future action may be taken, those dates could also be impacted if there is future action. So what we're looking for by way of a derogation is a promise, essentially, that irrespective of any action taken, those cases will proceed at pace. And if there is a break because the bar withdraws services completely and so things are not progressing, that those cases will progress in that space. Look, I would rather we didn't need the derogation. I would rather that we were now in a position where we are moving at pace with all the cases, because to be clear, any victim, any witness can be vulnerable simply with the passage of time and the pressure that it creates. Some, however, are much more vulnerable than others, and those are the ones that we're very much focused on trying to address. And certainly, based on our discussions with the bar over the last couple of days, there does seem now to be some progress in terms of scheduling of those 17 key cases. So there are only 7 now outstanding and awaiting a new date.
Thank you.
Good enough. Thank you, Minister. Thank you, Chair.
Okay, Doug, thank you. Minister, just before we leave this subject, a couple of things could I check with you? Are the family and civil bar participating in the working group?
Yes, it's the criminal bar are represented at it, but I think, if I'm right, that it's the criminal bar that the working group is focused on at this point in time.
Yeah, so the working group is all about gathering evidence in order to provide information so we can analyse what must change in future and so on. It's very specifically around the criminal legal aid rather than civil and family.
So that's the working group piece. The remainder of the bar, though, are content with the 16% uplift that we've offered, with the exception, as I said, of immigration solicitors, and we're doing particular work with them. I also, if I can, just mention that the work that I referred to Ciara on in the chamber on Tuesday. I actually have now corrected the record. You will be getting a letter from me, but just to put on record, yeah, that the increase was actually around 125%. I think I undersold myself when I said that it was 30%. I think that was based on an original calculation that had been done, but it's since been worked out about an increase of about 125%, and that's about £1 million per annum for that work. So although it sounds like a large increase, actually, relatively speaking, it's a relatively small amount of money that we would be investing in that space. But look, there will be other parts of the Enabling Access to Justice programme when it comes to the wider review of fees on an ongoing basis that the entire bar and Law Society and so on will be involved in. This is a very specific piece of work recommended by Judge Burgess, and that's what we're focused on at the moment. Also to say that ultimately it is for the Law Society and the Criminal Bar to decide who they send to a working group. We don't dictate that to them. So at the moment they would agree that it's probably representatives of the Criminal Bar who are the ones who need to be engaged most closely in that, because they are the people who, if you like, what was described as swings and roundabouts, where you get slightly more for some cases, slightly less for others, but overall you feel that you've been fairly remunerated. It feels that over time, with the complexity of cases, that's been broken. And so I think that's why we feel that this is a particular piece of work that needs to be done to re-establish the basis on which we pay. Yes.
I mean, just to reassure, the working group's already started, it's already met.
Yeah.
We've had a first one, it was quite positive as I understand.
Yes, and
So
we know
people are
that you've
plugging
kind
away.
of done away with your reference group and gone straight to a working group to save some time as well. Just 2 further points on that. Presumably, whatever issues you're scoping in terms of alternatives, you're also going to work on an evidence base for that, because it would be very difficult, I think, to justify, not dealing with the bar in certain aspects because of an evidence base, but dealing with others without an evidence base.
Yeah.
That's the first point. And the second issue then is with regard to the immigration issue that you've just raised. It's quite a considerable difference to move from 16% to 125%. Is that in line with, how was that figure arrived at, and how does it compare to, they had wanted a set fee, I think, of roughly £1,000. So what was the thinking behind the 125%, and what does it equate to in actual hourly rates?
Okay, so I don't have what it equates to in hourly rates, but I can say that first of all, it was based on a piece of work that was done in England and Wales with the immigration solicitors there, and the work that they did in this space is what has informed our work. So the fee structure that they were proposing would be the equivalent for Northern Ireland to bring us into line would be 125% uplift, which is about £1 million a year cost to the department, and that is affordable for us. I think I just have this as well. Advice and assistance in asylum and human rights cases, the fixed fee of £1,000 plus VAT, or inbuilt hourly rates up to the base limit of that. So that's one of the things that the immigration solicitors have asked for. There's 3 demands that they have. Eligibility for advice and assistance for persons held in Larne House Immigration Detention Centre should be non-means tested in the same way that it would be under PACE. And that would be remunerated as per PACE remuneration. And then the tribunal fees would double to a fixed fee of £2,400 with inbuilt exceptionality provision for cases that go beyond 12 hours of preparation to be calculated at £90 per hour. So that's roughly what they're asking. Now, we are actually having a look. We're having a look at what that would cost. We reckon that would cost somewhere between 800,000 a year to about 1.25 million. What we had proposed with the 1.25% uplift would cost about £1 million. So I think we're in the same space, which is why I think this will be able to be resolved reasonably quickly. And the reason and rationale for it, I think, is first of all that immigration law and cases have become much more complex over recent years than they were when these fees were initially set out. And there have also been a lot of changes in the immigration structures, not something that we have oversight of, as you will appreciate, but that has led to this change. That's been acknowledged in England and Wales, and they've looked at their fee structures, which is why we're also looking at ours.
And does that require consultation, Minister?
In terms of?
Going to 125% uplift. I suppose the thing that slightly concerns me is, everybody here dealing with stuff here is 16%, and that's not at this stage being compared to England and Wales.
Well, we have a more generous system,
Okay.
and the work is not necessarily like for like, which is why we can't do a straight read across. England and Wales figures were actually considered in terms of rates in part of what Judge Burgess did, just to reassure you on that. The reason that England and Wales is the comparator that we've used in terms of the work with the starting point, if you like, for the work with immigration is because it is the same immigration system and it's a UK-wide process.
No, that's fair enough. I just
And
wanted
in
to
terms,
understand.
yes, in terms of consultation, because I think that's a fair point to make. Obviously, we will be bringing this through as secondary legislation, so there will be an opportunity. We're out to consultation at the moment, as you know, on the programme, and people will have an opportunity then to feedback through that process. And we've asked the Bar and the Law Society to do so across the spectrum, not just on criminal. And then we will also have the opportunity through the secondary legislation to get feedback not just from the committee but from the Assembly and beyond.
And the evidence base in your scoping for alternatives, you're going to look at that too?
We will have to look at that too. We will have to look at other systems, but you will appreciate that I would much prefer we got the reassurance that we need now that we don't have to go down that route. And that would be my first priority, is trying to resolve the dispute so that we don't need to get into that space.
No, that's fair, because you don't want to have to reinvent the wheel, I think.
Correct.
Right. Everybody done on Criminal Bar Association? Thank you. We're moving on now to the Cresswell Simpson case. Deirdre?
Yeah, no, thanks very much. And I know we've been communicating with the department on this, Naomi, and just to say thanks for widening the scope of the review, because I think we all want to make sure that this doesn't happen again or to try and prevent it. But I just had a couple of queries around, in the review it talks around in terms of offending behaviours, and it was just really to try and see if we can get clarity on what constitutes offending, because in this case we would be concerned that that's not limited to convictions, but rather it was around his abusive behaviours. And, you know, there were cases where I suppose we want to know or satisfy ourselves that those behaviours were being picked up. So it wasn't necessarily just looking at, you know, as I say, the conviction. So it's to try and get clarity. I mean, conscious you might not be able to provide that now, so it would be good in a written follow-up. And the other issue was, I suppose, around cooperation with other agencies outside the North. Because conscious as well, this individual, you know, through the equestrian world, went to the south of Ireland, went across the water as well, and just to see, you know, if there was any cooperation, will that be looked at in terms of the scope? The other bit was around, just in terms of the public protection arrangements, and obviously Jan, who's doing the review, I mean, she's obviously an expert in terms of the field she works in, but just will the department be working to give her the experience around public protection arrangements and particularly offender management arrangements? Will she have an update on how those things operated from a safeguarding point of view? Because I know her expertise would be around domestic violence and stuff, but that may not translate over in terms of managing offenders in the system. So it's just, are you satisfied, you know, that those issues will be looked at? And as I say, you might not have all of that today, but be keen just to get some follow-up in terms of those.
Well, first of all, I think it's important that now that the review has commenced, that I don't provide running commentary on the review and its terms and conditions. I think it's important that I hand that over to Jan and allow her then to, if she feels that she needs further powers or further scope or whatever, but she was content that the terms of reference were sufficiently broad that they would allow her to follow whatever path she needed to in order to be able to bottom out what happened in this particular case. They are expansive and they do provide the reviewer with the scope to look at any and all issues that she considers relevant to the case. In terms of cross-border cooperation, cross-jurisdictional cooperation, obviously that is something that I can't compel as Justice Minister, but it's something that we would expect if that's where the investigation leads. And certainly in my engagement, both with the Safeguarding Minister in England and Wales, Jess Phillips, and also with Jim O'Callaghan as Justice Minister in the South, and previously with Helen McEntee, we have very strong relationships in this space. And also I should obviously acknowledge my counterpart in Scotland as well, Angela Constance. So I think that there are opportunities here for, I wouldn't imagine that there would be barriers being thrown up to cooperation in that space, because I think when it comes to violence against women and girls, to domestic and sexual abuse, we're pretty much all trying to find ways that we can work together in a cross-jurisdictional space. So that would be one thing I would say. In respect to clarity around the behaviours, it will not be limited solely to convictions. It will also be limited to other information. So, for example, from Health and Social Care Trusts about having presented in that space as well. And then I suppose the last point you asked was about how the reviewer would be able to engage with the system. I think it's important to say that probation, for example, so the management of offenders is covered under the probation, PSNI, Social Care Trust, and obviously prisons as well, in terms of any work that they may or any input they may have. The other organisations represented on the Public Protection Arrangements Northern Ireland or on the Multi-Agency Risk Assessment Conference can be invited also to participate in that review at the discretion of the reviewer. And as you rightly say, I mean, that's something that she is more than au fait with in terms of the need to have access to those. We have had very positive responses from those organisations who have already been approached in terms of saying that they're willing to engage, and hopefully we will be able to provide some useful learning for right across the system, because I think that there is something inherently concerning about the case, but not just this case. I think about a number of cases over recent years where we have seen vulnerability being exploited by individuals who have behaved in a predatory manner, and where often vulnerable victims are not aware of their previous conduct. So it's something that I think we can all learn from, and we will certainly, any learning for the Department of Justice and our agencies, we will be taking away and acting at pace to deliver on.
And just a quick one, again, it's probably just one for you to take away in terms of the review. It looked at the Western Trust, but my understanding is in terms of looking at Cresswell, and indeed the victim, obviously they lived in the Southern Trust.
Yes, that's
so it's
correct.
Just to make sure
and there's no issue with that either.
Yeah.
Again, as we've already said, we scoped it based on what was already known, but gave powers to the reviewer to be able to go beyond, to be able to expand and invite other agencies. And obviously, if at any time she's not receiving full cooperation, I have no doubt that she'll make us aware as the department of that, and we will be able to ensure that she does.
Mr. We've written to you on this because our fear is that as all of these things materialise and there are recommendations forthcoming, our fear is that there won't be any one place where leadership will be taken to ensure the recommendations are implemented. So we have written to you on this basis to kind of highlight, look, we are a bit worried that because dear knows where this could lead, and there are other cases where there are other cases working their way through the system that could maybe feed into this review. So we've written to you on that basis about, okay, well, how do we make sure, because you know yourself, so Jenny, they get recommendations and then they go back 2 years later and stuff hasn't moved on. So we just want to make sure that things don't fall down because there are too many cooks. You know?
Well, I mean, I can give you my assurance that I initiated this review. I mean, there, as you understand, there isn't a legislative basis for a domestic homicide review under the normal circumstances because of the date of Katie's death, so it didn't fall within the purview of that. But I initiated this review because I think that the issues arising from it are significant and serious and warrant that consideration. And I can give you my guarantee that when we get any review report, we will certainly be following up on those issues that are core to DOJ's functions and the issues, but we will also be putting pressure on other ministers and departments to do likewise, because unless we approach this in a collaborative way, we will not be able to do it. Safeguarding, for example, is the responsibility of the Department of Health, but Justice has a key role to play in it, and so on and so forth. So what we want to do is ensure that there is a cross-executive approach to this, and before bringing this review forward, we made executive colleagues aware of it, and there has been a supportive environment at the executive for this to go forward. So I would expect executive ministers to want to ensure that they actually follow through on the learnings as well.
Lovely, thank you. Deirdre, you done?
No, it was just because I suppose when you have it concluded, then you'll be meeting with those relevant ministers, because obviously health is one key area of concern. So no, as long
there
as
may
they
be others. I
No,
mean, there may
100%.
be, you know, through
Yeah.
sport and communities, there may be learning in that space. It has also raised some questions with us around things like abuse of trust offences, because up until now we've always looked at specific. The way it's been done has been by specific categories. So, for example, at the minute it's religious institutions and sporting organisations. But I'm also conscious that there could be other areas where people are equally vulnerable that simply have not surfaced at this point in time. And we're actually now looking at how we can better strengthen that abuse of trust legislation as well, to look where in situations particularly where you have people where there is a difference in the power structures between adults and young people, or indeed just between participants in any activity.
Okay, thank you. Right, members, we've got 35 minutes and 11 areas to cover, so right. Seriously now. Right, Stephen, Policing Board Review.
Yeah, thank you, Chair. Thank you, Minister, for your presentation. It was just to pick up on, you'd written on the back of the review that in January that you'll take time to consider the report and the review, and I suppose I'm just keen to tease out how long is that time to take. I suppose what are the next steps and how we can make the Policing Board more efficient and effective for everybody ultimately.
Well, I think the most important thing to say is that the review actually was, as a health check, a reasonably positive outcome, in that it said that the board was by and large working well. That's not to say that it didn't highlight areas for improvement, but I think we should all take some comfort in the fact that the review didn't find that this was a structure that was either past its sell-by date or completely dysfunctional. So I think that is encouraging. Obviously, we've published the review, and I want to, if I can, take the opportunity just to thank the review panel, Paul Sweeney and Dr. John Topping, for their work. The Policing Board are considering, obviously, the issues for them, police for them, and department for us. As you know, we had a tripartite meeting on the 20th of February to discuss it from those three partners, and it was felt by all of those present that it would be useful actually, because there were some areas where we could immediately recognise the content of the report and say, yes, that's something we've heard or something that we've discussed before. There were other areas perhaps where people had questions about what exactly was anticipated or what was meant by certain parts of the report. So we're going to have a presentation from Paul Sweeney and John Topping on the 7th of April, and then we will continue to work beyond that to see how we go about implementing those recommendations which we accept, because of course, as with every review, it may not be every recommendation that we accept, it may not be every recommendation that we feel is appropriate, but what we do know is that we want to look at those areas which we think will enhance efficiency and effectiveness of the board's role in scrutinising and holding to account and supporting the Chief Constable in his work. And so I think those are the areas that we're going to look at first.
Thanks,
Okay,
thanks,
Stephen.
Chair. Yeah.
Thank you. Anybody else on police board review? Lovely, thank you. Number 4 then is the Northern Ireland Civil Service Handbook. Doug?
Yes, Minister, I've passed you this on a number of occasions. You'll know, Minister, that the DOJ levels of sick absence are higher than everywhere else, and that's because of the Northern Ireland Prison Service. Northern Ireland Prison Service had 96 assaults over this last 12 months. The rest of all civil service put together is less than a handful. Can you honestly not see that what we really need is the Civil Service Staff Handbook, which I know is not yours, but we need to fight for this, needs to have an annex in it which is specific purely for our prison service?
Well, I think there are a few things to take on board. I think, first of all, the assaults on prison officers, it has to be said, in the same way assaults on police officers are completely unacceptable. And it is my view, and it is the view of the Director General, that we need to take a zero tolerance approach to violence against prison officers. And I've set out before in questions that both Doug and others have raised, the fact that it's not just under prison rules that people may be adjudicated on for that violence, but it may actually, they may receive further criminal convictions as a result of it. And I think it is important that people recognise that they are under a duty to cooperate with the prison service when they're in our custody and in our care, and that violence is not acceptable. So I think that's the first thing in terms of reducing the amount of sickness. The other issue I think is that we need to factor into this is not just about assaults, and I know that you bottomed that out actually with the Finance Minister earlier in the week, but it is also a highly stressed environment where people are exposed to trauma on a regular basis. And so, as you know, I have done a lot of work in terms of, for example, ensuring access to the PRRT and support systems for prison officers. You know, when you go in to open up a cell in the morning, you don't necessarily know what you're going to find on the other side of that door. Increasingly, they are dealing now with people with complex, very complex mental health issues, addiction issues, and really complex needs. And so the stress of the job also has an impact on the working environment in which prison officers work. So it's not just where there's violence, it's also their day-to-day work that has become, I think, stressful and complex. And I suppose the third thing I would say, Doug, is that when people are off sick, when there are higher levels of sickness, and that's coupled with an increase in prison population, which it has been over the last number of years, people again will see sickness levels rise because people will suffer from burnout. And that is a real concern that I have, which is why I gave the go-ahead for us to recruit more prison officers and to do that work. And hopefully we'll see that by the end of the summer, start of September, we will see those officers in total on the ground and actually being able to implement it. In terms of the Civil Service Handbook, look, we've had this conversation many times about the need to understand the working environment of prison officers and its distinctive nature in terms of the exposure to trauma and to violence. And I think that is an entirely valid issue. But I think on the Civil Service Handbook, that's not necessarily the only place where that can be done. We do have HR people who are embedded within Northern Ireland Prison Service from the Department of Finance who are able to understand those nuances. So, you know, I think there's always room for improvement, but maybe it's best if I hand this across to Hugh, because obviously HR is Hugh's Billy Wick, not for me as Minister to be dabbling in, so it's probably better that it comes from you.
Yeah, well, just to support, I suppose, what the Minister said, the handbook is intended specifically to apply to the whole civil service, but it is negotiated centrally with representatives of all the trade unions, including Prison Officer Association and so on. So it isn't as though it's closed off and it's only for some kind of traditional image of a civil servant who happens to work in an office or come up with policy or whatever. It's intended to cover everybody. There are mechanisms in it as well. To be fair, Mr. Beattie, they apply to everybody, all of the civil servants, but they specifically deal with injury. So when there's a case of injury or there's a case of disease or there's a case of assault or something which has happened from a third party, then there are kind of ameliorations built into things like sickness absence periods, how long you might get sick pay for and so on. So it isn't as though it's not dealt with. There are provisions in there that are intended to deal with it. Generally speaking, across the service then, we are very conscious of issues about sickness, and we have a very supportive environment for staff where we try and make sure that everybody is looked after while also trying to make sure that the taxpayer gets value for money. But injury, stress, anxiety is common across all of the civil service, perhaps injury less in relation to or other civil servants than the prison service. So we recognise it's kind of a multifaceted problem which causes sickness absence across the service, and we're working centrally but also within the department to try and resolve and improve those issues.
Hugh, I hope the Minister doesn't mind that I come back to you on that, because it raises a very good point. Because if you look at the staff handbook and it talks about excusal of sick absence, it doesn't allow you excusal of sick absence for mental health issues, which the Minister herself mentioned. It only talks about injury and it only talks about disease. So it doesn't take into account that very uniquely stressful issue that are faced by prison officers. And I have to say that the embedded business support team, human resource team that's in there from the civil service, not a single one of them has ever been a prison officer. So they don't actually understand fully what they're going through. And I have to say this again, that we're still using the word inefficiency for officers who are off sick due to mental health issues. So I still think there's a huge piece here, if I can please. There's a huge piece here which says, yes, prison officers and staff are civil servants, but their role is so diverse and so unique compared to the rest of the civil service, they must be looked at some way differently than the rest.
So, in relation to paid absence and waiver and the extension, it is limited to issues of, for example, injury, disease and assault, but that can include psychological injury. So while it might not specify mental health per se, if there's an injury which is a psychological one which comes from that environment.
Hugh, can I jump in, please? Sorry to jump in on this and to drag it out. That's not the case, because I tried that, and the answer I got back from the civil service was no, and they used those three key words you've just used. They would not allow us to use the combination of people who have mental health stress because of the role in the prison service. So they specifically said no to that.
Well, look, forgive me, Chair, but if it's a psychological injury, I'm not saying it's every mental health issue, but if it's a psychological injury which falls within the policy, then it should be covered. I'm very happy. I don't want to get into any individual cases, but I'm very happy to follow up separately.
Yeah, thanks. Just on the back of that, I suppose it links together, obviously, with the figures with the assaults on prison staff that have trebled in the last 4 years, from 32 in 2020 to 96 in 24. That included with the pressures on the prison service. I suppose linking in just with the recent recruitment process, I'd be keen for an update on that, given there's 150 vacancies, I believe, in terms of actual prison officers, and yet you were going out to recruit for 75. So even with that, it'll still leave a significant gap. So I suppose just keen to hear more around that. Any solutions on that?
Well, I mean, the business case that was brought to me and the request from the Director General was that we needed to recruit around 75 officers, and I was able to give the go ahead to be able to do that, and I think that was what the request that I received was. Now, of course, we could probably do with additional officers at some stage, and that's something we can look at as part of future budget settlements. But we do have the resource to be able to recruit those 75, and some of those are already in training, and some will be passing out. I mean, we've had a number of passing out parades actually here, and attestation ceremonies here in this building.
I missed it with COVID.
Yeah, I know. But there have been a number in this building, even just over the last year. There have been a number of those attestation ceremonies over the last year. So I'm optimistic that we will get to a situation where we have, if you like, the right size of prison service. But I think there's a wider issue. If you look back to 10 years ago, levels of assault and potential challenges in the prisons would have been higher. So we went through a low period. If you compare, for example, now with the COVID years, you're going to get a completely different window, because now we have significant numbers of prisoners who are doubling up, for example, in their cells, where during COVID no one was doubling up. We had a much smaller prison population in 2020 than we would have now. So the comparator is not the same. And it's true to say that as the prison becomes more overcrowded, and as the prison becomes more and more full, it becomes much more tense an environment. People's ability to be able to withdraw, to be able to find space, to be able to manage emotions and tensions become much more acute. So it is a more stressful environment, and we are acutely aware of that, which is one of the reasons why we have invested so heavily in the mental health and well-being of the officers who are doing that job at the moment. Our prisons are, and the reviews that we have from Sagini show this, are a much calmer and more stable environment than they were for many years. We shouldn't lose sight of the fact that even with an increased population, that remains the case. But that doesn't diminish the fact that every single assault on a prison officer is completely unacceptable. And as I say, we need to take a zero tolerance approach to that. And as you know, as part of the sentencing bill, which I'm hoping to bring forward, we're looking at other assaults on public workers. But we need to take cognizance of the fact that when someone is providing that service within the prison service, that has to be respected, and that they cannot be going into work either expecting to be abused or feeling that if they are, it's not taken seriously. I think we're clear as a service in terms of how we deliver that is not the case, and I think most prison officers would recognise that. As with respect to the issue of psychological injury, Doug, we can obviously go back and bottom that out with the Department of Finance, but it's certainly my understanding that where it's psychological injury as a result of something that has happened within the workplace, that can be addressed through the current policy. But we will bottom that out and seek clarification on it for you.
Yeah, of course, and I wouldn't want to just focus on one case, and you're absolutely right. Now, but listen, thank you very much.
I think I suppose to just follow up on this finally, we visited Magabry and we met with kind of round tables of people, and we moved around. At every table, this was the main issue. And with former prison officers that we've met, this is the main issue, because in many respects they regard themselves as much more akin to policing than the civil service. And our frustration as a committee has been, we flagged this up to the Committee for Finance, we flagged this up to the Department of Finance, and we're pretty much stonewalled. You know, the civil service is the civil service, but everybody within the prison service, to a man, and I think the Director General included, would take the view that what is there is not taking account of the unique environment that they face and the unique risks that they face, and people are leaving that employment, some of them in a very bad way. So, and actually leaving much earlier than they should in terms of age. So our concern is, if everybody in that arena is saying, look, this is not working for us, really, is it okay for the Department of Finance to just say, well, tough, you're civil servants? And that's our view. Everybody just seems to be stonewalling. And so from our part, we would quite like, Minister, if you and your Permanent Secretary would take that up with the Minister and the relevant Permanent Secretary to say, really, we're not convinced that this is sufficient and that prison officers are being treated appropriately given the risks they face.
Yeah, it's this. Doug raised the issue of efficiency and inefficiency, people being dismissed for inefficiency due to absence. I mean, those same phrases will be used when PSNI officers are on long-term leave. So it's not unique to the Civil Service Handbook and the Civil Service Handling, where PSNI officers who are working in an equally challenging environment or were members of the civilian staff in the PSNI are off on long-term leave and are unable to return to their duties. The same kind of approach is taken. So the HR approach that's being taken by the Civil Service is not unique. I accept that the language is suboptimal, to be polite, and I accept that for people who have been going through a lot, it can be quite hurtful. So I don't dismiss in any way the fact that language is difficult, but there is a degree of legalese around some of these issues that has to follow due process. Maybe if I could just ask Hugh to come back just on the specifics around HR, because I'm very clear that there is a kind of firewall when it comes to HR between me and the service, and I don't want to tread into that space.
So I'm very happy to take it away, Chair. I will discuss with DOF colleagues. Ultimately, as you know, DOF is in charge of the civil service in terms of terms and conditions, but it negotiates everything centrally with trade union side. We have a people strategy in formation, which the Civil Service Board is pushing forward for the next 5 years. It includes regular review of all of our policies. I'm very happy to go and talk to DOF colleagues in relation to the
It would be helpful
prioritisation.
because they're just too keen
And
to
I'm
shut it
happy
down.
to take Mr.
Hugh.
Beatty's
So-
points in relation to that as well.
No, that's
if that
helpful,
helps,
thank you.
Chair.
Anything else on this? Right, moving
Can I
on.
also just point
Sorry.
out that we can get you some statistics that might be helpful in terms of prison officers who have accessed PRRT over the last year in terms of the balance between physical and psychological issues, because that might also be helpful just to shine a light on the balance, at least for that cohort who are accessing PRRT services, so we can provide that for you.
That'll be helpful, thank you, Minister. Okay, moving on to item 5 then, which is the Office of the Police Ombudsman. Deirdre?
Yeah, it's just Naomi. You'll know that there's a couple of outstanding investigation reports. So it's just to get a sense of if you know how many there are still outstanding, and if you know when they're likely to be published. And the other question is just around obviously the resourcing for the office. You'll also be aware obviously that they're assisting with the OMA inquiry, and there's additional resource needs there. So it's just to see if the department are obviously looking at those issues at the moment or have had engagements on them. Thanks.
Well, I think the first thing to say is that the reports, there is a deadline, I believe, for those reports of April, end of April, for legacy reports. And that has to be concluded. My understanding is that there is one of the reports that may be delayed beyond that point, but with the agreement of the NIO. But the remainder of those reports will be delivered on time. So that is the most recent information that I have.
May be delayed, sorry, or will be at this point?
I'm not sure.
I mean, ultimately, it's for a pony to decide when it's going to release reports or not. There's a legal deadline on them in relation, if I could use the shorthand, for the legacy reports, which is the 30th
You
of
believe
April.
they will be delivered then on time?
I know that they've pushed really hard internally to get the work done and so on, and there is an intention to see what can be done in terms of getting them all out.
But my understanding is that there's no suggestion that the deadline can't be met. I mean, I did when the Ombudsman was absent through illness. I did raise this issue, as did the Ombudsman's office, in terms of seeking a delay and an extension to allow the reports to come out I suppose in a more orderly fashion rather than rushing towards the deadline. But that didn't gain any traction. But my understanding is it can be done. The challenge may be that what you have is a series of reports happening over quite a short period of time, but that's unavoidable given the legislative deadline. But it's ultimately a matter for the Ombudsman's office to manage rather than the department.
Thank you.
Funding for the inquiry.
Yeah, with respect to funding for the inquiry, I mean, my understanding is that as things stand, will have to be dealt with within the Ombudsman's within their budget. But I do think that there may be some approaches being made to us, if I recall correctly.
So certainly, all inquiries, once they're established, result in the bodies that respond to them having extra costs and so on. It has been suggested that some money would come from UK Gov, but it simply doesn't normally work that way. We'll continue to ask for further monies in relation to lots of legacy things. The Minister's been engaged in that before. In relation to the OMA inquiry in particular, the Office of the Ombudsman will approach us, I'm sure, because we provide the funding and so on, and if they can put together the evidential basis for it, it will be properly considered as with any other kind of business case for expenditure. But ultimately, for example, in this coming year, we still have a 60 million opening pressure. There'll be all sorts of other bodies, including PSNI, for example, which have to respond to it, but we'll absolutely look at that and help as and where we can.
I don't think we've actually received a request.
Nothing at this point.
I don't think we
No.
have, no.
I don't think so.
But you'll keep it under review then if it, okay.
Yeah.
Thank
Ultimately,
you.
it becomes a statutory duty that
Yeah.
each individual participant must respond to the inquiry. There's necessarily a cost to that, looking through old files, looking through papers, bringing the information forward you're asked to do. But no extra central money gets delivered to the Department of Justice to help everybody with that. But the duty must be complied with, so we will do our best in terms of distributing money.
It is a concern that both I and the Chief Constable have raised on various occasions around the continuing cost of legacy to the Contemporary Department. I don't think that anyone at the transfer of powers in 2011 would have appreciated or anticipated the degree to which legacy would still be so high up the agenda in terms of not having been concluded in terms of the processes, and also would have cost as much as it has over the last number of years and continuing to do so. And it is a drain in terms of the budget for the Ombudsman's Office, for the PSNI and for others who are participating either in inquiries or are having to do legacy investigations. And even with the ICRIR in place, there will be potential costs that don't fall within their purview because the cases fall outside of the timeline that has been established for their work. What we have said, however, where the PSNI has to provide information to the ICRIR or any of the other justice bodies, that is to be a separate accounting line, so that will be paid for by the ICRIR, because my understanding is that they're funded under AME rather than DALE, and so it makes sense that they should cover any costs that are attributable to the work that they do. But there is still a cohort of cases that fall outside the ICRIR. And there's also still a lack of clarity as to how, for example, that will interplay with the restarting of inquests and other things, and how that will be paid for and how we will. So it at the moment, it is literally how long is a piece of string, because we don't have the clarity we need to be able to do any cost estimates. But it is an ongoing challenge, and it's one that I think we do need to engage the UK government around, because I don't think that legacy should be carried actually by these institutions. I think it should be carried by the two governments, if anybody is going to make a contribution in that space, when it comes to actually funding the work that needs to be done to provide truth and justice for the individuals who deserve and need it.
Minister, can I just follow up on this issue about the deadline for reports? You'll be aware, no doubt, about my involvement with the Kingsmills report and the deeply unsatisfactory response that there's been from the Ombudsman's Office with regard to that report. And I'm not going to get into the specifics of one case. However, what I do want to check with you is, in the event that the clock is run down and people receive reports towards the deadline or at the deadline, do you anticipate that where people have questions about reports that the Ombudsman's Office has written, that the Ombudsman's Office will answer the questions, as opposed to redirect victims and recipients of reports to the ICRIR who have had nothing to do with the report?
Well, I couldn't answer that question, because that would be a matter for the Ombudsman's Office properly to answer, so I couldn't anticipate how they would handle inquiries regarding their own reports, though I accept your logic that it would make sense for the author of the report to answer the questions on the report. I think there is a wider issue, however, about whether those are questions simply about context and text, or whether those are questions about where next, because those are more properly for the ICRIR, as far as I can understand it, in the form that we're aware it exists as things stand at the minute. In terms of the running down of the clock and the fact that reports may come out very near the deadline, that was precisely the issue that I had raised with the Northern Ireland Office. There were two concerns that I had. The first was that you would end up with the reports coming out in an unseemly fashion, where individual atrocities were not given the breathing space almost to acknowledge the content of the report, to be able to come to terms with what was in the report and the findings, to be able to have the space to deal with that, and then before the next report would be issued. And my concern was that there was something just slightly unseemly about having this kind of very rapid dispatch of what are hugely significant reports in their own right. And I suppose the second thing that concerned me was that we could end up in a situation, particularly when there was uncertainty because of the ill health of the Ombudsman and her return to work, that we could end up in a situation where there was public commentary around the reports, but potentially the Ombudsman wouldn't be in a position to be able to speak to those reports. And I think that would be a very unsatisfactory situation, both for the Ombudsman and for families. And so what I had sought to do was to get an extension to ensure that when the reports were out, there was the space and time for people to be able to engage with the office and with the Ombudsman. And the opportunity for the Ombudsman to be able to respond to any concerns that people had. But as I say, that plea fell on deaf ears, and so there may well now be quite a few reports coming out back to back. I think that's unfortunate, but unfortunately it's beyond my remit, and having made representations, they weren't taken up.
No, to be honest, I'm appalled at some of it, because the Kingsmills one, the families were already told it was completed. They were told it was completed, and then that was retracted. They were promised they could have it at the closure of the inquest. We're 11 months on, it's still no report. And regardless of the number of times I write, and I'm well aware of what that office, how that office refers to me, but still no report for those families, and it's very difficult to see that there's anything other than running down the clock. Just with regard to the Ombudsman's office, I've got a couple of questions.
Just on the, before we move off the reports, I mean, to be fair, the Secretary of State has recently said that he will keep that deadline under review. So, you know, it is not beyond the bounds of reasonability that he may decide to move the deadline if he feels that that's necessary in order to allow people to get that information in a more timely and appropriate fashion. And certainly if the committee have strong views, they may wish to convey those directly to the Secretary of State.
My fear is that as long as the deadline is extended, the Ombudsman's office will take it and still will end up in a circumstance where, as you say, there will be an unseemly release one after another, and there won't be the time and space taken.
Well, my understanding, and it is only my understanding, and obviously the Ombudsman will no doubt at some stage be with the committee and able to answer questions directly, but I think my understanding is that they are programmed in terms of trying to release these in a more organised way, that it's not a rush to a deadline, but it may feel like a rush to a deadline simply because the deadline is so acute. And it may be that a bit of breathing space between each report, and whilst nobody wants any unnecessary delay, a bit of breathing space might just give families and those who may be involved in the reports a little bit of time to come to terms with the content of the report and a little bit of dignity in terms of how it's actually handled. I just think that a kind of bombardment of these reports where they almost get lost in the enormity of what's happening more generally, I think is not dignified, and I don't think it fully respects the sensitivities of the issues.
Minister, there are grave issues around satisfaction with the Police Ombudsman, and that's borne out in her annual report. In the office, I'm going to focus on the office actually. Within that report, it stipulates at the beginning that the Office of the Police Ombudsman is accountable to the Northern Ireland Assembly. You're aware that I tabled a number of questions to you. I can't get to the bottom of how exactly is the Ombudsman accountable to the Northern Ireland Assembly, because none of us can get answers to questions. In fact, I have not a legacy case, a present day case where a person made a complaint to the Ombudsman in August. They have yet to hear that the Ombudsman has received it, but we subsequently heard from the police. I submitted evidence on that case. I've written to the Ombudsman 5 times since October, and since January every month I am yet to receive an acknowledgement. I mean, and that's what I'm getting as an elected representative. I can't imagine how people feel. Now I see within the report, they cite, if we look at the stats around complainants, satisfied with the manner their complaint was treated, 43%. Thought their complaint was dealt with independently, also a low figure. Number of complaints to the office, 61. I suspect if people understood what the complaints process was and how it would be handled, there'd be many more, because I suspect we're all getting quite a lot. But that level of satisfaction, if we set aside the people who are discontent with perhaps the outcome that they didn't anticipate, but there are grave levels of dissatisfaction here, and there is no means to hold this office accountable for its service standards that I can see. Now, I appreciate that the Ombudsman sets their own target, and apparently your office gives them guidance, the department gives them guidance. I would like to have some understanding of the accountability mechanisms, the types of guidance that they're given, and what routes people actually have to express their dissatisfaction, and what can be done to improve these statistics, because this kind of thing, not even acknowledging complaints, is a huge issue.
Well, first of all, you will appreciate I can't answer for the Ombudsman's office, and there's a very strong reason why that is the case. The Police Ombudsman was created entirely independently of government, as with most ombudsman offices, actually, where they're not accountable directly through the executive ministers, because it would, for example, if you look at the local government ombudsman and the Northern Ireland Ombudsman's office and so on, it would seem inappropriate if you're making a complaint about government, that government would then hold the office that deals with that complaint accountable. But it does create, I think, the frustration that you've referred to, and clearly feel very strongly, in that there doesn't seem to be the normal accountability that you would have with other independent bodies.
Certainly when they cite the accountability mechanism is through the Northern Ireland Assembly, and not one Assembly member knows how that works.
Well, first of all, to be clear about how the structure works, the police ombudsman is appointed by royal warrant on the recommendation of the First and Deputy First Minister, in line with the Police Northern Ireland Act 1998, and it's set out in that act how this is to work. Neither I, as Minister of Justice, nor my department have any role whatsoever in the appointment of the Ombudsman.
Yes.
So despite the fact that the oversight is of policing and in the justice sphere, and despite the fact that their financial accounting lines are through our department, we don't have any involvement in the appointment. They also operate completely independently, and I know that this frustrates members. It sometimes frustrates me too, having to say it over and over again, but I have no role in performance appraisal for the Ombudsman.
Yes, you've indicated
At
that
all,
to me.
because,
could
yes.
you maybe outline for us, okay,
So,
well, what is the accountability and what guidelines do you give them?
Well, first of all, there's no provision in the Ombudsman's legislation or the management statement and financial memorandum for performance appraisal for the Ombudsman. So that's the first thing. Or for a review of the effectiveness and efficiency of the Ombudsman. Indeed, if the First and Deputy First Minister deem that the efficiency and effectiveness of the Ombudsman has fallen short of their expectations, they can ask the Ombudsman to retire. They cannot compel that. So that is the legislative structure, like it or loath it, that's where it is.
And is that the height of accountability?
And, well, it's the height of accountability when it comes to the corporation's soul that is the Ombudsman. In terms of the Ombudsman's office, there is also no legal requirement or no legal basis for us to, for example, carry out a review of the Ombudsman's office outside our normal governance scrutiny process that applies to all arm's length bodies. So each year we will have an annual governance meeting with the Ombudsman's office. That annual accountability meeting is with the Ombudsman and our Chief Executive, and that would look at, for example, their performance, their current and future activities, any policy developments that the department would be aware of that may impact on their activities. And that will take place on the 18th of March. So that's the first thing that will happen next week. That will look at their own operating plan and how they have performed against that operating plan. It would, of course, provide an opportunity for us to discuss things like customer satisfaction and issues like that, but they're not for me to hold them to account, though there may be issues that we can discuss. So there is a challenge, I think, in terms of those accountability structures. I can only imagine that if it says it's accountable to the Assembly, it is in the context of the office being accountable through the normal arm's length body processes, through the memorandum of financial understanding, as opposed to accountability for the Ombudsman and the actions of the Ombudsman herself. It is a strange office in the way it is constructed, and I can say that it's not widely replicated in terms of other offices, but it was made in that context. It was constructed in that way for a particular purpose, and that was that there would be no political interference in the work that the Ombudsman's office would do, and in the work that is directed by the Ombudsman herself. And that was the purpose of it being constructed in that way. They are, I think, and can be, to the best of my knowledge, and Hugh, you may wish to correct me on this, I think they can be reviewed by SEGINI. I think they may have powers in that regard. I know they do for PPS, for example, where they wouldn't fall within the Department of Justice, but I can't say that with confidence, and that's something that you may wish to raise with the Ombudsman herself or with SEGINI.
That's fine. Could I ask you, Minister, when you're having your conversations with the Ombudsman and the Office of the Police Ombudsman, that you would flag up some of these issues around customer satisfaction, the complaints process, and accountability and transparency, because it seems to me none of this is clear, and there's no means to address it. So I'd be very grateful if you would flag that up, because certainly there are massive issues here in terms of public confidence and how these investigations are taken forward. So I'd be grateful for that. Thank you. I appreciate that it's now 3:30. It may be helpful if, although we have covered some good ground, our members can tend to flag up to officials their questions, and then perhaps the department could respond in writing. Or how do you wish to proceed?
Well, Chair, if it's helpful, I mean, I'm happy to take a few more questions if it's helpful to members, but I realise that you have a very busy agenda, so I don't want to impose, but I'm happy to take a few more questions. I can't stay for another 20 minutes or so if necessary.
Right, well, we'll whiz through them quickly. Thank you. Minister, thank you. That's great. Let me get my list now. Right. Danny, you've got minimum age of criminal responsibility and reasonable chastisement.
Thank you, Chair. Minister, thank you for your time. And as a new member to the committee, I have been looking through the bill through the lens of better outcomes for children and young people. And particularly just want to ask you around the reasonable chastisement and increasing the age of criminal responsibility. And why is this not part of the bill? And in your view, could it be part of the bill?
Well, I think the first thing to say is that you will know that my own position is that reasonable chastisement should end. It's not necessarily a matter that I would be able to act on alone, in that it would require the cooperation of the Department of Health in particular, and wider cross-executive approval, because it would be viewed as a contentious issue. It has been raised with me. I have met with the Royal Society of Paediatricians and others, who have made a very strong case around reasonable chastisement and the dangers in terms of safeguarding and protecting children from violence and abuse that presents, because it turns what should be an objective decision of a social worker or a healthcare professional into a very subjective decision as to whether or not it is reasonable chastisement, and therefore whether or not it should be reported to the police or to other safeguarding authorities. So I would like to see reasonable chastisement come to an end in Northern Ireland, and I have explored that with executive colleagues. There has been no consensus on the matter, which is why it does not form part of the bill, because I did explore that. The second issue is about minimum age of criminal responsibility, and again that is something that I have explored at length with all of the other executive parties. Again, it's something that I feel needs to be addressed. The vast majority of young people who now face custody are 14 and above, because the youth justice system has been working in terms of policy to try to avoid custodial responses to young people below 14, and to try and avoid criminalising young people at young age in terms of the juvenile justice system. So in effect, by raising the threshold for criminal responsibility to 14, it would not necessarily have a massive impact in terms of safety, security, response mechanisms to juvenile offending. It would simply regularise the situation around how the policy is already being implemented. There were a number of variations. So there was to raise it to 16, which is the case in a number of other European jurisdictions, mainly in the Nordic countries, to raise it to 14. Which was my preferred option, because I believed that it struck a balance between a young person's development and recognition of the consequences of their actions, and the other is to which was explored by my predecessor, actually David Ford, was to raise it to 12 as a starting point, and all of those have been rejected in favour of retaining it at 10, and we've not been able to get consensus around this. We also looked at potentially exclusions for serious crimes, so serious sexual offences and murder, so that if you got into a situation where you had a young person who was between 10 and 14 who committed a serious offence, such as rape or murder, that they would be able to receive a custodial criminal sentence. And that still didn't provide sufficient reassurance for those parties who were not content with the change. It is something that I think we need to look at as a society. We have the lowest we have the lowest age of criminal responsibility in Western Europe, equalled only by England. And so I think it is something that we need to look at in terms of how we can take a more informed approach, particularly around child development and child psychological development and emotional development. Many of the young people who are committing offences in that very young cohort between 10 and 14 are young people who are themselves victims of abuse, of coercive control, of criminal exploitation. And so it is important that we don't criminalise those young people in a way that would deter them from seeking help for what has happened. I also think that we need to bear in mind that if a young person at 9, so below the age of criminal responsibility, were to commit a serious offence, whether that be murder, rape, or serious sexual assault, we would still deal with that. I mean, there would still be a public protection response to that. So it isn't that we would be leaving a gap where those young people would be free to offend without consequence. Whether the criminal age of responsibility is at 10 or at 14, those young people between 10 and 14 will still be held accountable for their actions, but it will be in an age-appropriate way and in a way that is about trying to prevent any reoffending, and in a way that will protect them and members of the public. And that should be, I think, at that age cohort, that should be the priority, as opposed to a criminal punitive approach.
So, Minister, just for clarity, I suppose raising the age of criminal responsibility, could that fall in the scope of this particular bill? I take on the point of reasonable chastisement, and I suppose the second follow-up question to that there would be, how do you think we could achieve it then?
Well, I think there's two things. I mean, both of them I think are within scope, because as you appreciate, the scope of the bill is incredibly wide. So yes, they would be within scope of the bill, in my view, depending obviously on how they're couched. The issue would be whether or not they would have consent. So as Minister, I recognise I'm not going to get consent from the Executive to move forward on either of those at this time.
Essentially, it needs to be the committee, and that's unlikely, so it would need to be a party or a number of parties together.
It's likely to be the case that it would fall to an individual member or an individual party to take it forward. With regards to how we make progress, though, because I do think it's important that this doesn't become a contested space, because actually that can heighten concern in the public that in some way they're being left unprotected, or that there's a gap in the law, or that I think it is important that we try to bring people with us. I think there are lots of things we can do that will actually improve the confidence. So reassurance about what happens between 10 and 14 in terms of what we do in the Youth Justice Agency at the minute, which leads to very few young people in that age category actually being sentenced prisoners within the youth justice system. I think that should reassure people that there are lots of other diversionary disposals, lots of other engagements that we can have that still keep people safe, that don't criminalise young people, and that allow us to maintain some integrity within the system. I also think that there's work we can do around reasonable chastisement about what that means, because I think why I approached the Health Minister first is that parental support would be largely for the Department of Health, and what we know is that where this has worked, so in Scotland and Wales where this has been advanced, and reasonable chastisement, it has been accompanied by quite extensive work around parental support, and ensuring that parents do not feel that they are going to be criminalised simply for trying to correct their children in terms of what they're doing. And there is no evidence in Scotland or Wales that is the pattern of what has happened. What has happened instead is that the fact that it has been made illegal has sent a message where parents are much more likely then to seek assistance if they are struggling with their children, and that assistance has been more readily available because there's been investment in parental support as part of the overall package. And I do think the two need to go hand in hand. I mean, I think to simply say to parents, that we're going to strip away, and I think it is right that I don't think any parent feels good about themselves after they smack their child, let's be honest. It tends to be when somebody has reached the end of their tether and they feel often very distressed about what has happened. So I don't think parents want to place themselves in that situation, but what we need to try to do is have the right supports in place to show people alternative ways of dealing with bad behaviour, alternative ways of seeking the support they need. And I do think that removing the right of reasonable chastisement, the most important and compelling argument for me is the fact that health professionals themselves are saying that reasonable chastisement for them is a cloak behind which abuse can take place, because it makes the decision as to whether something is reasonable chastisement or not a very subjective judgment for the professional. And those health professionals are often afraid to report an incident where they are uncertain as to whether a bruise is because of a smack or has left a mark or whatever it might be. They're afraid of over-criminalising a situation. Whereas if they knew it wasn't a subjective, it was a completely objective standard, they would be able to pass that on to somebody who could then look and say, what support does the family need to actually help them in these circumstances?
Right,
So
I'm kind of
I think
conscious
that's-
that I don't want our extra 15 minutes to be just one question. So, Connie, finally.
Thank you
Go
very much.
ahead.
Thank you,
Transformation
Minister.
bids.
Yes, I wanted to ask you about your transformation bids that your department was recently secured. I was hoping you could talk a bit more about the two and how they'll be taken forward, but also the unsuccessful bids, which I think you mentioned in your presentation you're going to be taking forward anyway.
So, I mean, look, I'm delighted that we got this transformation funding. These are things that we had intended to do. We were told we were to bring things forward that we were going to do as a department that would be transformative rather than come up with isolated pilot projects that weren't necessarily going to deliver, and that's what we've done. So the Speeding Up and Transforming the Criminal Justice System bid is actually cross-departmental, so PPS are also involved in that bid. And what we're looking about is financial sustainability, looking at early engagement in the justice system. So you'll appreciate we had a very long and involved conversation about legal aid, but one of the things we're trying to do is to reset and recalibrate people's expectations. Not every dispute should end in court. In fact, it is a failure of dispute resolution when it does end up in court. What we need to do, though, if we're going to ask solicitors and others to do more of that early intervention where they do negotiated settlements, mediated settlements and so on, we need to ensure that the legal aid system actually pays them for that work. So that's one of the recalibrations that we're looking at in terms of speeding up justice and saving the courts essentially for the most contested and serious of issues. So that's, I think, a really important issue. The other stuff that we're doing in this is around electronic monitoring. We're looking at how we can transform the way we monitor individuals, first of all on bail terms, which are set by the court after a person's been charged for a criminal offence, but before they've been to trial, or as part of their conditions in respect of a prisoner leaving custody to serve out the remainder of their sentence in the community. So you'll understand a licence, somebody released on licence, or somebody who's part of an enhanced custodial sentence where they serve part in custody, part in the community, and being able to use tagging in those cases may provide the additional reassurance that the judiciary are seeking, that will allow them to use those mechanisms rather than remanding people in custody for longer, because we do have a serious issue with the numbers of people being remanded in custody, and particularly those who are on remand. The last bid that we made, the one that I'd mentioned, was around the Department for Communities and ourselves to reduce reoffending and prison population, and that bid included bail support scheme, diverting people from custody, rollout of enhanced combination orders through probation board. So that wasn't successful, and we're having to look a little bit about the bail support element of that, because I think that that's one of the critical elements that we do need to deal with in terms of tackling the prisoner population. And as well as looking at the enhanced combination orders, which we're looking at further expansion in North Antrim around that to see if we're able to do something in the next financial year. So that will continue, but not as quickly as if the bid had been successful. The other area where we'd also made a bid was around the Tackling Paramilitarism programme, and we had quite a substantive piece of work that was on that was not able to be funded in this round. Some of these we will be taking into the next round of bidding, but what we have decided, there is a particular piece of work which is where we've identified a particular cohort of people who have been involved with paramilitary and organised crime groups, who at their first point of contact with the justice system, having offended, may, if offered the right support opt to leave those organisations and to exit those organisations at the earliest stage. So we've done a lot of work around how we can divert young people away from being groomed into those organisations. But I think what's really helpful in the programme we're looking at the moment, which is called CIRV, it's CIRV, so let me think through the acronym, it's Community Initiative for Reducing Violence. So what we're trying to do, we'd originally hoped to introduce a harm reduction hub, but what we're going to do is take forward the CIRV part of that. And what it's about is where a person comes, for example, is arrested by the PSNI or is questioned in relation to an offence, and it's clear that they are involved with organised crime or paramilitary groups, that they are offered specific support to allow them to exit that as an alternative to going straight through and into the custodial system. And so it has been operated in places like Boston for years to deal with gang-related violence and coercion. It's been used in Scotland as well, where they have looked at people who are getting involved, for example, with drug gangs and organised crime gangs. And it's many of the people who will come through the system will not necessarily recognise themselves as having been coerced into their activity or having been groomed into that activity. But often when presented with the reality of their situation and also what their future looks like, they will want to exit that particular activity and do that at the earliest point. So this is in addition to the diversionary work, and we're doing some of the work around this at the moment, and we are hoping to pilot this I think starting later in the year. So it's something that we want to test, as with everything we do through the Tackling Paramilitarism programme. We want to test it, we want to build up the evidence base, and we want to show that it works. And if it does, then it's something we can consider for further rollout if eventually we can get to the harm reduction hub that we're aiming for.
That sounds really good work, Minister. Thank you. I think did you get feedback from the board as in regards to the applications that weren't successful that you could then take forward for the next round that could hopefully be secured?
Yeah, I mean, in particular, we got really strong feedback around from the board, and officials from the Reducing Offending bid are going to be meeting with their counterparts in the Department for Communities and so on to take forward a new bid in that space that will perhaps be more robust and more likely to succeed. We're hoping that amended bid then could see us a bid into, I think in summer 2025, the new round of bidding will be launched. So we're hoping to bid into that process. I mean, we have been fortunate. I'm not going to say lucky, because there was a lot of hard work went in. I think that's how luck works, isn't it? It's 90% hard graft and 1% luck. But from our perspective, we work really hard as a department to look at transformation opportunities. And what we haven't always had is the capacity and the money to be able to deliver on them. So this transformation funding has actually been a lifeline for us, in that it has allowed us to take forward things that we genuinely believe in 5 or 10 years' time, if fully rolled out across the department, could find significant savings which we could then reinvest in other parts of the justice system and actually deliver a much better service. So I'm quite excited about the transformation stuff, I have to say.
Thank you.
Minister, thank you very much. I think what we'll do now is appreciate, I've got Ciara, Stephen and Justin, but what we may do, because you've given us the extra 20 minutes, I think what we may do is take those questions in writing and send them through to the Minister, and we'll get responses that way if members are content. I'm just conscious that forensic science are outside, and the Minister's already given us their extra 20 minutes.
Well, look, I genuinely thank you for the opportunity, and happy if members have particular questions at any time. Members of the committee want to come and meet to discuss any of the issues. I'm also happy to do that. I mean, don't feel it has to be through a formal committee stage of this discussion. If you want to come and meet me about any of the issues that you were going to raise this afternoon and haven't had a chance to, if you get in touch with my private office, I'm more than happy to do that, and we can do it on a Monday or Tuesday, so you don't need to go too far out of the building on a sitting day to have that conversation.
No, thank you, because I would really appreciate it, particularly because it is around family courts.
Yep.
And I know you've had correspondence, and
yes,
you were going to meet officials this week, and obviously ourselves have had lots of correspondence on it, so it's a kind of key area.
If it would be helpful, Chair, again, I'd be more than happy to arrange a meeting with members of the committee who have a particular interest in this space we can get that set up and we can have a proper discussion about it, because it is a very involved issue, and not one we could do justice to this afternoon, but it is something that's really important. It's also somewhere where I think that there is some progress being made in terms of the conversations I've had with the LCJ, but I do think that there is a wider conversation we need to have about openness and transparency right across the piece, including in the family courts.
That'll be helpful.
That'd be helpful. Yeah, that would be really helpful. Yeah. Thank you.
The whole committee will be at that. So.
Yeah.
Thanks very much, Hugh. Thank you very much, Deborah. Probably the easiest committee you've had, Deborah.
I did say before we come in, if they ask me anything really tough, I'm going to say I think that's for you, Deborah. But I didn't have to fall back on that. So thank you very much. I really appreciate your time. Thank you.
Appreciate it. Thank you. Members, could I ask those of you who didn't get a chance? I'm sorry. Obviously, you'll appreciate we covered some considerable ground there. But Ciara, if you could submit your questions, or if you can do you want to let us know now what your questions were?
No, I think the family court questions are quite generic around coercive control and just the recommendations from the Gillen review and stuff, and I think it is more pertinent to have a sit-down meeting and conversation.
Okay,
so I'm happy to do that. Obviously, secondly, the ones where was just in relation
service.
to the prison service,
Yes.
and the level of remand, and just between what's the ongoing work between the Department of Health and Department of Justice in relation to obviously mental health, adverse childhood experiences. How is that just being integrated across the prison service and the system? So they're quite general.
That's fair enough. Stephen, you had stuff on.
I'm happy enough to follow up after, or through the normal channels with questions and in the chamber and so on. So I'm content with a lot so far. Thanks.
Have we lost Justin?
Yeah.
Yeah, I think we also might want to check. You'll see that in the Law Society's response, they had indicated that the underuse of the domestic abuse waiver is primarily down to the fact that it's just so involved, and so it's really not worth people's time and effort. So maybe we need to look at, okay, are there ways in which the domestic abuse waiver could be a bit more streamlined to make sure it could be better used? Maybe we could ask that, or what's being done in that space, Deirdre?
Just a quick one again to add on to Ciara's point in terms of pressures on prisons and the cross-departmental work, particularly with health. There was a case recently, young Sophie Rogers, it's in the public domain, so that's why I'm naming her, who was remanded into Haybank because there wasn't enough sane care home places. And obviously, she's the mental capacity of a young child, but obviously in a prison setting. So I'd be keen to know, are there other cases like this? And what work is being done to try and find an appropriate space for that individual. So just kind of linking into some of that work, if we could get a bit of clarity, that would be
Also,
good.
if we can follow up on that, because that's going to have an impact on the prison setting itself.
Yeah, 100%.
Okay. Is that everything, Stephen? You're sure
Yeah,
you
I'm
don't want to?
content. Yeah, at the minute.
Okay.
Thanks.
We'll also, guys, if you can follow up with Justin, he had questions around domestic abuse criminal proceedings and the programme for government, just to make sure that everybody gets their chance. Is that okay? I'm sorry, but I think we made the most of our time, but we always run out. So the minister had to be away, so apologies for that. Right, are the guys there from Forensic Science?
Yeah, they are.
Thank you. Members, I would ask you, as we move into agenda item 5, I would ask you to turn to page 128 of your meeting pack, and that goes up to 185 for the relevant papers. I'd like to welcome to the meeting Alison McIlveen, who's the Chief Executive of Forensic Science Northern Ireland, Stephen Campbell, who's the Director of Laboratory Services, and Ian Craig, who's the Head of Biology. Folks, you're all very welcome to the meeting. Thank you very much. Apologies that we're running slightly behind, but we had a lot to get through there with the Minister, and we still didn't make all of it. So thank you very much for your forbearance. We're really glad to have you with us. We've received your written submission, which is helpful, and we've got a number of questions to follow up with you on. But I'm going to hand over to you initially, to make your opening remarks, and then we'll take it from there. Thank you.
Well, I'll keep it very brief, Chair. So good afternoon, everybody, and really thank you for the opportunity to come today. This is a first for me, and I think actually a first for the agency. So we really want to tell you, I suppose, about the services that Forensic Science provide and the preparatory work that we've been involved in ahead of the enactment of the Justice Bill. So as you introduced there, these are two technical colleagues, so to be honest, I'm looking right or left here when the technical questions come in. So FISNI is very much an operational organisation. It's really all about the science. So our role is to provide objective scientific advice and support to enhance justice. The Department of Justice is very much led on the development of the legislation of biometric attention periods, and we have fed into that, I suppose, to inform them with regards to our processes to make sure they can be taken on board. And really, we will ensure that we support and deliver the implementation of the legislation, whatever it may be. So we've provided some detail already in the briefing in our role in operating and managing the Northern Ireland DNA database. And it is important to stress, even at this early stage, that profile deletion will only occur when we have received notifications. So it will be the PSNI who will notify us, and we will delete those profiles. So as I say, happy to take any questions you may have. If there's anything that we're not prepared and have with us today, we'll certainly take that away and provide some more detail. And I would also like to say that we would be very happy to offer the committee a visit to the laboratory, if that might be helpful in helping you understand the kind of scientific processes that we undertake.
That would be phenomenal. Thank you very much indeed, Alison. For those of us who are anoraks, that would be really appreciated, and I'm certainly one. Right, members, in our housekeeping earlier on, we didn't get a chance to reach you guys, so could you just indicate as usual, please, if anybody's got questions at this stage for Ciara?
Yeah. So thank you very much, and I'm delighted this is your first opportunity. Hopefully, I don't know if it's one of many now, but thank you for coming along, and obviously, just as a citizen first and foremost as well, just knowing the work that you do, I wasn't aware. So that's probably my first question. Just in your own general opinion, are citizens in North fully aware just of their rights in regard to the appropriate and proportionate retention of their data, which you are processing?
I would think they're probably not very much aware of us as an agency. We're not very public facing, and we're very much in the background, doing the science, providing information that informs investigations. I mean, as a citizen, and even speaking to family members, I would suggest that people are probably not aware, but perhaps in the general population, but perhaps offenders or those who are maybe whose DNA has been taken, perhaps they might be more aware of the processes than the general population.
Yeah, I think as a sample is taken, there is a declaration. It's actually discussed with the individual at time of sampling. So the PSNI or custody officer would actually explain what the DNA sample is for and how it will be used and speculatively searched on both Northern Ireland and obviously national DNA system. But as Alison rightly said, it's probably more for people who are being sampled as opposed to the general public.
Sorry, and just to add to that, we're probably all aware of the CSI effect, and there's lots of programmes on TV, and people in general are very interested in forensics. It's not as sexy as what it comes across on TV, I have to add. But in some areas it's much more technical than others. And actually the recovery of evidence is a very laborious kind of labour-intensive process. It's when it gets to the kind of the profile itself, it becomes much more technical. But no, I think, other than what people see on TV, I think that's what is informing them.
I've just two more, is that okay? I suppose secondly then, could you take us through just the process regarding the deletion, how deletion works in practice and how it takes into account the existence of different databases with different retentions and disposal schedules? How does that happen? Is there any improvements or challenges that you envisage arising from the introduction of the new retention and deletion schedules? So it's generally around that area, around the deletions. And then just thirdly then, the Justice Bill, as you know, doesn't clearly define biometric data beyond fingerprints and DNA, and does not explicitly include custody photos. So just in your view, is the definition of biometric material contained within the Justice Bill sufficiently clear? Just those two areas.
If I maybe start with the latter point. I watched the Biometrics Commissioner from Scotland give evidence last week, and obviously they talked about the whether once a photograph is turned into an image and it's searchable on a database. And I think that Ireland would also consider photographs as well, although I do understand that the department are looking at it being dealt with separately and not necessarily through the bill. We don't hold photographs or databases. We would maybe have the odd scene photograph in a file or something like that. So it's not a biometric that we will need to deal with ourselves. In terms of deletion, at the moment, and I mentioned it in the brief, until there are retention periods agreed, we don't delete. Now, we delete the odd profile at the minute, and maybe Ian could probably touch on the circumstances or Stephen around that, but it will only be when retention periods are agreed and we get notification to delete that we will then. So what we're doing is concentrating on ensuring that our systems have the capability of responding to mass deletion, and therefore after that, deletions of a month or whatever the frequency is that we receive from PSNI.
Is there any, do you face any challenges with your current system?
No, because really at the moment we're not doing any significant deletions, but we know that it needs to be developed in order to do that. So that is the part that we're working on. We're making sure that our system is developed in order to, I suppose, comply with the bill.
You just mentioned, I'm curious, there's a few deletions. What would they be? I know because at the minute it's indefinite and you're holding the material indefinitely.
In terms of numbers, you're probably only talking about a dozen a year that we would normally see coming through the agency at the moment, because as Alison explained, there's indefinite retention at the moment, subject to the bill go live. But in reality, instruction or notification is received from PSNI Biometrics Unit, and then it's a relationship and messaging between the local database and the national DNA database. So as you know, where we actually produce subject DNA profiles, and by that I mean DNA extracted from an individual or known source, it's loaded to Northern Ireland DNA database and then subsequently to national. So we actually receive a deletion request coming through from the PSNI. We delete from both the local database and then request a deletion from the national, which is then confirmed by a deletion request report.
And what requests? What he says about 12. Why would you get a request to delete at this moment in time?
Normally it's through the PSNI process, which is the Biometric Ratification Committee. So quite often an individual request for their DNA profile to be deleted. That would be considered by the BRC within the police, and should that be deemed appropriate, we would be instructed then to delete that profile both locally and from national systems.
Thank you.
Well, you don't care, is it? Deirdre.
No, thanks. And it's following up on that, and I imagine like a good lot of these questions as well will go to the police, because they're the first step in the process. And obviously just from your report in terms of if the bill does go through, it will have an immediate impact in terms of thousands of deletions. And it's just understanding the difference between the different data sets and databases, so it would be easy to manage in terms of the north. But as you say, that national database, and I'm not sure if there's even an international database in terms of some of the work, child trafficking or maybe other issues. If you request, so if we have one set of retention periods here that differ to England or Scotland or Wales, if we request that, then is it your understanding that deletion does happen in those other databases, that will be, and they will come back and confirm? And are there any circumstances where they would reject that, that you would be aware of?
No, absolutely not. I mean, once we put a deletion request in, it's essentially PSNI's data, and once we request to be deleted, that is obviously actioned by the National DNA Database.
Okay, and that's the way it works at the moment then, and
Absolutely.
you envisage that's how it would work?
Yeah,
in
even
the
for
new-
these small deletions that we're doing at the moment, when we actually move to bulk deletions, the process will essentially be the same.
Aye, so ultimately, the owner of the data currently then, even in those national databases, are to the jurisdiction here then?
Correct, yes.
Okay. Thank you.
Can I just follow up on that one? So ultimately then, it wouldn't make any difference if the other databases have a different time frame from ours. If it's our DNA and we say we want it deleted, then it's gone?
Correct.
Okay, thank you. Can I check something else? Do you envisage, as the new bill is commenced, or the new legislation would be commenced, any circumstances in which the police would say, delete this, and you would say, no?
Absolutely not. To be honest, the instruction from the PSNI is quite clear. We really have no information to suggest why we wouldn't delete a profile that was requested to be deleted. So it really is a binary action.
They don't give you any reasons why not, or anything of that
Quite
nature?
often, very little. All we really need is a unique identifier for that particular sample and the instruction to delete, and then we follow that through both locally and nationally.
And for them to do that, does that come from one person, or do a number of people have to sign off on that?
Generally comes from the PSNI biometrics unit.
Okay.
Again, I'm not totally au fait with their current process in terms of sign off, and the BRC obviously would have a big action in terms of signing off profiles for deletion.
Yes, I suppose obviously I want to check that, and we'll follow up with the police just on the basis of there's potential for corruption. You know, so just not suggesting that people would, but there's potential, and would like to see gaps closed where
And there's
where they make
potential
sense.
for error, but
Yeah.
you know, and we in terms of the retention periods, you know, we don't have access to criminal, you know, records or anything like that. So it's not our role to second guess whether this should be deleted or not, or in fact, because it's quite complex. There's quite a lot of different deletion periods and stuff like that. So effectively, we just need to make sure that if we're asked, that we will do it, and then we need to make sure that our system is robust in that regard, and we will give them confirmation back. So we will provide notification that what they've asked us to do has been done.
And are you wanting this point or
no,
separate
that's
point?
fine.
Right, Deirdre, you want in this
It's
point?
just on this point in terms of, suppose, when you're moving then, if the bill does progress, as I say, you're going to see thousands then in terms of deletion requests with the capacity issue. I don't know if that's primarily then with the police, but what impact that would have on yourselves, and have you looked through that and working with the department?
In terms of the actual
In terms of
DNA
doing the
profiles
deletions and stuff
itself,
then, yeah.
it will be an IT solution in terms of the bulk. So we will make sure that we have obviously some sort of file transfer process in place with the PSNI. We'll articulate the profiles that they want deleted. It's in terms of a manual process, it simply just could not happen that particular way. So we're currently working with our incumbent supplier to look at some sort of software solution to allow that to happen.
And there's no delays in terms of those national databases then? You don't envisage anything if the solutions...
There may be
Okay.
a couple of days
Knock on-
in terms of, so maybe if we actually approach the National DNA Database and ask them to delete 40,000 profiles within 24 hours, that may be a challenge for them. But again, we'll work that through in terms of that end-to-end process. But in reality, it might take them a couple, maybe 3 days to delete that level of
But
profiles.
there's no additional system that they need to develop. You think there's the capacity or the systems in place?
It's already in
for-
place.
Okay.
Because they're already deleting
Yeah.
in England and Wales now, of course, getting maybe 40,000 from us on day one. But that's the sort of thing that we will have to work through, and that's the process and the conversations that we would have. Stephen attends the fines board, and obviously and is also on the PSNI Biometrics Project Board that's just been set up now to develop, I suppose, their mechanisms and systems for doing that. We will need to make sure that when we get a message from them that our system is able to deal with it, and obviously we'll be involved in any user acceptance testing with them to make sure, and that's in a safe environment before we go live, that it works. But that's something we're already looking at that. We have already our system's quite a very specialist system. It would be, it's a local company, Equinity, still called
Yes,
Equinity?
Equinity
ITS,
yeah.
change their name every few months, who supply services for us to maintain our database. So we have been kind of saying to them that, broad brush kind of specification, which is what we're going to need. So this is something they're already kind of looking at. So once we know irrespective of the retention periods, that's not relevant to us. It's the kind of delete. Yeah. And we just need to be able to do the deletions from the system and confirm that it's been done.
So can I check? I suppose previously, whenever there were biometrics provisions passed by the Assembly, they weren't commenced because the PSNI needed a better and an updated IT system, and they weren't going to be able to deliver it. Is their system for that different from yours? I mean, do you have distinct requirements in terms of a system, and will your system also need to be updated and changed?
We are quite fortunate in that all we're looking for is a single message from the PSNI.
And that's it.
Delete.
And your
it's
process,
a binary,
everything remains the same for you?
Without speaking on behalf of PSNI, their systems will be so much more complex in terms of dealing with the retention schedules associated with the bill. There's no doubt about that.
Okay. But for you, no change?
Very simple message.
So, would there be any change? Are you future-proofing the system in relation to biometrics and various types of data? Can you what data are you currently holding from a biometric point of view? I'm just thinking of voice recognition, facial recognition. Into the future, will your current system be able to cope with that?
It won't. It's purely the Northern Ireland DNA database is integrated with our DNA management system. So it's basically integrated with the software that we actually use to generate DNA profiles as well. So it's not purely a local database. There's lots of different system functionality built into it. But in reality, going forward, we are going out to procure a new system over the next 4 years, but it'll be purely for basically keeping DNA profiles and obviously system functionality that we currently have and want to expand. So there'll be nothing further in terms of that particular system development.
Just on your point, we don't do gate analysis, we don't do CCTV analysis, those are not services.
Yours is essentially samples, isn't it?
Yeah, we provide. So in terms of biometrics, we do DNA and we have, I suppose you could say fingerprints, but we don't have fingerprints database. We recover fingerprints, but we provide those to PSNI and they go on their database. So those other services as a laboratory, we don't offer currently anyway.
Annie?
Thank you, Chair. Thank you. We recently had the Information Commissioner in the committee, and they stated that children are more in a vulnerable position when it comes to biometric data, and said extra safeguards were required to protect their rights. I'm just wondering what measures that you have in place to make sure that's the case.
We currently have nothing essentially in place at the moment. Again, our system is quite simple. Where a sample is submitted, we profile that sample and then add it to the local and national DNA databases. So at the moment, I mean, we have approximately 25,000 individuals below the age of 18 currently residing on the local and national systems.
So, all we do is upload the profiles that we're asked to upload, but we do have the ability to pull information from the system. So actually we were able to check in advance of coming here, how many were considered children or youth at the time of sampling. And now this is cumulative. I mean, the database is in operation since '96, so we're nearly 30 years in. And these subjects are maybe no longer youth or children. So, but they will be deleted like anybody, else. And so the police will have. That's why it's much more complex for them. Yeah. So if the bill stipulates specific retentions for children, and it's much shorter than the 25, 50, 75, then effectively it will be down to the police to comply with whatever those retention periods are, and then they just tell us who to delete and we will delete them. And so therefore what we could do at a later stage is go back and look and see how many youths or children profiles are we still holding. Clearly there's not that many going on, and given time we could do a bit of analysis to see was a lot of that in the early days, and are we still getting, because I did catch the Minister just outside talking about very much diversionary for kind of 10, 14-year-olds and that type of thing. So there's probably less children being caught up in the system now. But we could, if there was something specific you wanted, we could see if we could pull information.
Hey, Tony, can I check? You indicated that you'd heard the Scottish Biometrics Commissioner last week. He raised a really interesting point about source DNA, and this bill kind of would have that once a DNA profile is extracted, that the source material would be destroyed, and he thinks that that could be a loss or a lost opportunity in future, because if you don't, as technology advances, if you don't have the source material, you may not be able to do things that you could have done had you had it. Do you have a view on that? Could you maybe elaborate on that a bit for us, what that might look like?
Well, certainly if once a person's DNA is taken, and we carry out the standard DNA 17, which is the system we use at the moment, and profile, that gets added to the database. There are other DNA technologies out there at the moment. One which was just recently is YSTR, which involves looking only at male's DNA, and it's especially relevant in offences against women, sexual offences, so it's especially important for those. If you destroy the original sample of the DNA, then you subsequently can't carry out any subsequent testing because the sample is in effect gone. Now, you can retain the sample if it's taken under SIPIA legislation. You're allowed to retain that sample for...
You need to help us out with that one, Ian.
SIPIA is...
Criminal Procedures Investigations Act.
Thank you.
Which basically allows on certain offences for you to retain the DNA, the source DNA, as you call it, until the whole case has been resolved, so that allows subsequent testing should you require it within that particular case.
I suppose just adding to that, the source of DNA may often be recovery from an item.
Yes.
So we would get exhibits into the laboratory where, Stephen's team would be manually, maybe bloody garments and stuff like that, or looking for, trying to recover, see if we can recover DNA in order to get a profile. We don't retain exhibits. Once we've completed our work, those exhibits go back to the police. But obviously there's a lot of legacy work as well, and that has gone on in the past. And often what happens is those items will be retained, and they might come into us again at a later stage because there's a much more sensitive type of DNA procedure for us then to search to see whether or not we can recover any DNA through our more sensitive, because this is a very fast-paced area of science. This is one of our areas that is constantly moving.
I think the main differences between whether you're referring to source DNA, as in the DNA from the subject, which the bill covers, and source DNA, which would be, as we would refer to as crime scene DNA. So DNA that you've recovered from exhibits or from the actual crime scene itself. When we get a DNA profile from a crime scene, that doesn't and won't be destroyed. That will be retained because it's not covered under the legislation, this bill. It's only the subject DNA which this bill covers and would be deleted. So, in terms of DNA recovered from crime scenes, that's retained by the organisation, which allows then for continued investigations or appeals or criminal complaints review commission, those types of issues. So we retain those.
You retain them, or the police, sorry, in terms of the objects then?
The items?
Yes, they retain the
retain
the items. We will retain the profile that was developed from those. Sorry.
Okay.
Can I just build on Ian's point as well? The SIPIA approach that Ian's referring to is already in place. We've actually been working through that regime now since 2019. So in reality, if an investigating officer or a sampling officer doesn't identify that particular item as SIPIA, in other words, keep it for further potential testing, the sample that doesn't carry that flag is destroyed after 6 weeks. So that is the regime we are currently working under. But in reality, what we're seeing is, and that's why we have had to re-engineer a lot of our processes to take this into account, because obviously you have significantly more storage now associated with retaining samples for longer if they have been flagged under SIPIA. But that process is in existence at the moment.
Ciara?
Just one other thing, just as regarding the numbers, and you were able to say 25,000 young people under 18, in relation to subject profiles, because people can be arrested on numerous occasions and get their DNA taken at every occasion. So when you say subject profiles, is that in relation, one subject profile is an individual, or is one subject profile potentially could be 10 different times?
People used to be sampled a lot.
Yeah.
And again, it was a PSNI, and to be honest, a kind of a UK-wide initiative to move to a single sample. So essentially, when we actually generate a DNA 17 profile for a subject, it does not matter how many times you profile that individual, the profile will remain the same. So should an individual be brought into a custody suite, if DNA has already been taken and a profile generated, they don't necessarily have a second sample taken. But what they might do is relife any tariff associated with that particular DNA profile held on a database. And it's to reduce the costs associated with repeatedly producing a DNA profile when that result does not change.
There are no processes through which your DNA could change, not if you get transplants or you've got,
fingers cut,
blood.
Ian can't wait to answer that one.
He would like to have a go at that. Yeah, this one. Yeah.
I suppose the reality is, yes, on extremely rare occasions, usually related to a bone marrow transplant, a different DNA profile can be expressed within the individual. Now, usually what will happen is that they express their original DNA profile in some tissues, but they might express this new DNA profile in different tissues. So maybe from the cells of the cheek, which is often where you get your DNA sampled from, might be your original DNA profile, but your blood could possibly give the profile of the bone marrow donor. That expression of that bone marrow profile can vary, so sometimes it can build up and sometimes it can fade away. But in my experience in the lab of over 30 years, I'm not aware of any case in the UK where that has been an issue. I am aware of sort of issues across the world where this has occurred, but I think it's on one or two occasions that this has proven to be an issue.
Again, it's back to the anorak and the true crime.
Yeah, so
among us.
I suppose, technically speaking, if you're watching CSI, yes, it would happen all the time. But in reality, it has never, that I'm aware of, been a factor in any UK or Ireland as an issue.
Sorry, that's just in the DNA sample, so fingerprints could be potentially different, could they? In terms
Fingerprints
that would be
are wholly different. Everybody's is
that
unique.
Can't change,
it's just
just the DNA.
Twins, where your DNA will be
identical twins.
Identical twins.
Okay. I just had one further question, if I may, which is, you've already identified 40,000 samples that you think are going to have to be deleted, and then you anticipate around 500 a month.
Yes.
How have you identified those? On what basis?
Discussions with the PSNI. So when they applied a blanket kind of view of the data that they held, there was in around 40,000 initial profiles that are being deleted. And then obviously with the tariffs in place with the new bill, we basically did a bit of a ready reckoner in terms of what we were likely to see month on month. And that's where those figures were derived. It was really from the PSNI in terms of their estimates.
Okay, so we should be asking them how they came to those
Yeah,
figures, really?
yeah.
Okay. No, that.
I mean, we've
it's
about
helpful.
225,000 subject samples on our database at the minute, but we deal with an awful lot of serious crime.
Yeah.
So obviously, and given that DNA's, we've only really been running the database in '96. If we're looking at 75 years for serious crime, there's an awful lot of our profiles that will not be impacted by immediately.
No, that's fair enough. That's me done. Does anybody have anything else then, Deirdre?
It's not to do with the Justice Bill, so it's obviously just in terms of the forensic science lab itself. So employment opportunities, training opportunities for young people. I'm just keen to know how they would access or find out about that,
You're just
or
looking
what
for a next
engagement you
career,
do.
are you?
No, it's not for me. It's actually young
She said
people
young
who
people.
For a friend.
I'm away, even in Catholic
We
church
actually
terms,
were at a
I'm
career
way
fair in
beyond.
a school in Carrick this morning. We get an awful lot of requests to come in and do work experience. Sorry. I mean, you have to be CTC cleared to be on our site, and obviously we're dealing with very sensitive information. And we would do nothing but work experience if we facilitated that. I mean, honestly, the number of requests that we kind of get. But what we want to do is go out more and maybe provide more information. So we've done a lot of schools and we've done universities. In particular, we're trying to do our bit to promote STEM. So we actually had an email in from the head of the chemistry section in Queen's the other day saying thank you so much for coming and helping us, because we're seeing our numbers start to go up. Because this is, people think you go and you do a forensic science degree. In a forensic science degree, it's very generalist and there's very little science in it. It's kind of not what we want. We want chemists and we want, with obviously the increase in drugs and toxicology and stuff like that, that would be a big area for us. So, and biology is all about chemistry. So we are very clear on the kind of requirements that we have. So we're doing a lot of outreach. Yeah. So if if there's a school you maybe want us to come to or something like that, there's opportunities for our staff because they get to develop their communication skills and their presentation skills. We say it as a win-win. And some of the sections can take a bit of equipment out and that looks a wee bit more, kind of CSI. But some of the others is not just as, doesn't come across as well.
It's key one, it's the pathway. So I suppose even around university and even the way they do with the legal profession, where Queen's and others would create those pathways and look at apprenticeships in.
Yeah.
So I'm wondering, are you exploring things like that in terms of that pipeline of talent
It's
coming
where you
forward?
want to enter the organisation.
Yeah.
We have lots and lots of opportunities at the junior level, which is assistant scientific officer.
Yes.
And to be honest, as evidence would kind of show, we pretty much run annual competitions for staff at that grade, and we do attract high numbers of staff that actually are applying. We're also running a scientific officer competition this year as well, and again that's going through all the public press, the NICAS recruitment websites. We really do try and promote recruitment. The challenge is, I suppose, going forward is retention. So where we are seeing a lot of people come to the organisation, it is tough work, it is challenging work. And in reality, over the past few years, we've actually struggled to retain staff at that junior level.
We have considered apprenticeships. It's not easy to kind of introduce these types of things, and the reality is, whilst we're not struggling to attract candidates at the assistant scientific officer, and you only need O levels. It's O level science. It doesn't need to be at that level, and then they can work their way up in the laboratory side of the house. When it comes to reporting officers who go to court, that's at degree level, so it's a science degree. It's also, we have found some challenges. Maybe some specialist areas. So we have a road traffic collision team who go to every single fatal road traffic collision. Now they're engineers, so it's mechanical engineers we're looking for. And I personally chaired 3 back-to-back competitions, and to be honest, they're not queuing up to kind of apply for those jobs. But given the nature of the job, you probably don't think you're going to go and do an engineering degree, and that's where you'll go. So, and I think also, which I'm sure you'll hear, the pay is a challenge as well, because engineers are paid quite well. But I'm hoping that with the 2 imminent pay rises, that might make it a bit more attractive.
That's great, thank you.
Everybody, can I just do one other? Just final, and it's nothing to do with the bill either. It's just I'm very keen, particularly in genealogy, and I have volunteered my DNA. Obviously, from an income generation point of view, have you ever considered any other private work?
To be honest, it wouldn't pay us. We did actually look at it at one stage. I mean, all the DNA profiling we do is non-coding. So bar gender, it actually tells you nothing really physically about the individual. We did look at it from an income generation perspective, but the time it would take to kind of set up that work stream, there's companies out there at the moment which are just dedicated to that particular activity. Yeah, and they're cleaning up is probably the best way to put it.
There's too many in the market, and the processes are very streamlined. But we have done some private work.
And as well, we're only allowed to carry under the Human Tissue Act in relation to criminal investigations. So
Right.
we would need to expand our sort of allowances under the Human Tissue Act to allow us to do that for any other reason.
We have done some income generation work in the past. We've done work for Pakistan and for Poland. There tend to be one-off consultancy type of pieces of work that we've done. But yeah.
I thank you very much. You've been very generous, actually, even in terms of going beyond the bill, so thank you. But I trust that demonstrates the committee's interest in the type of work that you do. It's been lovely to have you with us. I trust that your first time hasn't been too bad, and hopefully we'll see you again. And thank you very much for your offer of a visit. I'm fairly certain that we would really enjoy that. We'll take you up on that at some stage.
We're building a new lab as well, by the way. It's a huge investment. We're working on our full business case at the moment. We're pretty confident that it will proceed, and it's going to be massive. We're going to have probably, at the time of opening, I would say the best lab in Europe. That's what I would say. So it's a few years away, but yeah. So come now and then.
Before and after.
Yeah.
Absolutely.
That's great.
Thank you. Thank you very much.
Very much indeed, folks. All the very best. Thank you. Members, agenda item 6 is correspondence. Could I ask you to turn to pages 186 to 236 of your pack? As ever, I'm going to draw your attention to a number of items, and then I'll open the floor so you can all have an opportunity to comment on any other items in which you have a particular interest. First item is item 6.4, which is correspondence from the Department of Justice at page 196, and that's a response to the committee's request for an update on cross-departmental working to address reoffending and work in respect of short sentences and other options available to the judiciary. Just to advise you that correspondence JCP/25/36 referred to in the correspondence, and this is page 197 now, that's a written briefing on the consultation on the new single community order for children that we considered at last week's meeting. So members will recall that the committee has requested further information in relation to that matter. Okay?
Yeah.
Are members content with the department's response, or do you require any further information or clarification?
Content, yeah.
Thank you. Item 6.7 is correspondence from the Committee for Finance at page 207 of the pack, and that's an update on the capital easements highlighted in the spring supplementary estimates because of an ongoing legal challenge. Are members content that we would ask the Department of Justice to provide details of any justice projects that have been delayed because of this legal challenge? Great, thank you. Item 6.8 is more correspondence from the Committee for Finance, and that's page 208. It's a copy of correspondence from the Department of Finance in respect of work with the DOJ during the review of defamation law in 2023-24 and the Department's role with strategic lawsuits against public participation, otherwise known as SLAPS, in that task force. Are members content to note this, or do you require any further information?
Noted, yes.
6.9 is correspondence from the Law Society of Northern Ireland, page 210. At our meeting of the 13th of February, we received oral evidence from the Law Society of Northern Ireland, and we agreed to request the Law Society's views on how wider system reforms could assist solicitors, particularly in respect of family law cases. Are members content with the response, or do you require any further information or clarification?
I think we're content at this stage, but I think the areas that have been raised we can discuss with the Minister and the meeting with the Minister, particularly around the Family Justice Board and the creation of that and stuff. So
that's fine. Members, are you content to note the other items of correspondence as set out in the memo, or do you have any further comments to make, or is there anything else you want to raise on them?
Noted. Just I suppose I know Connie touched on it with the Minister, the transformation bids, but just if we can be kept updated in terms of the correspondence, but also particularly the body in line with the contract, that we got the oral briefing on for the tagging, just as part of that transformation bid and that new contract, when they have a timeline of when they can start to look at GPS monitoring, just for us to be updated on those things, it would be good. Thanks.
Okay. Agenda item 7 is the Forward Work Programme. There's an updated Forward Work Programme at pages 238 to 247. Are members content to proceed as outlined in that Forward Work Programme, subject to any changes that may arise as a result of availability or whatever may come up? Yeah,
yep,
thank you. Agenda item 8 is Chairperson's Business. Could I ask you to turn to page 249 of 50? You'll see that the Director of Public Prosecutions has invited me as Chairperson and Deirdre as Deputy Chairperson to an informal event for MLAs to discuss some themes that were identified during a perception audit of the Public Prosecution Service. I think that the Deputy Chair and I will have a conversation offline about our participation in that, but are members content that we attend in the first instance?
Yeah.
Thank you. Agenda item 9 is any other business. Do members have any other business they wish to raise? No. Then date and time and place of next meeting is going to be next week, which is the 20th of March at 2 p.m. in this room. Thank you very much, members. That's the meeting adjourned.
Committee Room 30. Sound. Committee Room 30. Sound. Committee Room 30. Sound.